We often hear the place we know as Brisbane described as the land of the Yugara and the Turrbal people. But why the two groups of people? Early ethnographic material identified a language called the Yugarapul or Yugara, spoken in the Brisbane area, and 5 distinct clan groups who spoke the Yugarapul language, but who had definite geographic demarcations. The first group was what was called the Duke of York's clan, occupying the Brisbane metropolitan area on the north side of the river where we are now. This is the group called the Turrbal. The leader of the Turrbal over a period of 20 years from the 1830s to the 1850s was called the Duke of York by Europeans. An important camping place for that group was Barrambin, which was then known as York's Hollow and now Victoria Park. There were a number of killings of Indigenous people and burning of camps in York's Hollow in the 1850s and 1860s, driving out the Indigenous people who camped there. The second clan group was known as the North Pine or Petrie clan in the north of Brisbane. The third one was the Coorparoo clan on the south bank of the Brisbane River. The fourth clan group was the Shapara clan of the 8 Mile Plains area. And the fifth was called the Yerongapan clan of Oxley Creek, or the Yeronga area to the south of the city. So Yugarapul or Yugara describes the broader language group occupying the whole of the Brisbane area, while Turrbal describes the clan group inhabiting the area where we are now, just north of the river. By the 1860s, all of these communities had largely been dispersed, to use that euphemistic expression, from their traditional lands. It is important for all of us to remember and to acknowledge that Indigenous people have lived here for many millennia before European settlement, and that our presence here is at the cost of their violent dispossession. And it is particularly important to do so at this event, concerned as it is with the law governing the recognition of native title of the Indigenous peoples of Australia. Now, welcome to the Federal Court's Native Title Forum for 2025. I particularly want to welcome Justice Longbottom, who, as you know, is a very recent addition to our court and who is very well known to all of you who practice in native title. I also welcome President Smith of the Native Title Tribunal, who is here, and other members of tribunals. And I also want to acknowledge the presence of Justice Collier of the Federal Court. This is an important event in the life of the court. The community of native title practitioners, including barristers, solicitors, and anthropologists, is a small one. Our area of practice is specialised, complex, and often difficult. It is important that we can come together to share our collective knowledge, experience, and expertise at events like this. Because it's a small community, I'd like to take this opportunity to meet those of you I don't know or have only seen across a crowded courtroom. So please introduce yourselves at morning tea and at lunch. And I'm sure that the same also applies to Justice Longbottom, to President Smith, and the courts and tribunals registrars, including registrars Nicola Colburn, Simon Grant, and Josie Salzman. Now, I'd like to introduce our first speaker, the Honourable John Mansfield, AMKC. It's a fair assessment of his career to say that he is regarded as one of the great judges of the Federal Court. John was a judge for 20 years from 1996 to 2016, and was particularly respected for his judgments in the quite disparate areas of native title law and competition law. John was the native title docket judge for the Northern Territory and the South Australia, and presided over many, many native title cases, including, notably, the Larrakia claim over the Darwin area. Another important case was the groundbreaking Timber Creek compensation claim, in which he was substantially upheld by the High Court. He was also appointed as the Aboriginal Land Commissioner in 2011. Incredibly, he delivered some 145 judgments in native title cases over the span of his career. It is difficult to think of anyone who has applied more thought and thought more deeply about native title law. Please welcome John Mansfield.
Thank you, Darryl, and thank you all for coming to listen. I hope I don't, by speaking to all of you, many of whom I recognise again, seem too repetitive, because I was asked to give a lecture on this topic, and something which a number of us have discussed over a lengthy period of time. The appropriate starting point sometimes is said to be the visit of Captain Cook in 1770. But we all know that many, many thousands of years before that, some 60,000 years or so, the first Aboriginals gradually came to Australia from the north, from Asia, and did so over many generations. In that period, there was a sea gap between the Australian continent, which included New Zealand at the time, New Guinea at the time, and the Asian continent, and the sea level was something over 100 metres lower than it is today. So there was no gap between Australia and the rest of Australia. That landmass was slowly occupied by the new inhabitants from the north, and they spread throughout Australia. There's no history of the succeeding thousands of years, save for the oral traditions of the Indigenous Australians and what has been observed and interpreted since then by anthropologists and archaeologists. There is still a lot to learn. I want to just tell you of one of my privilege occasions. An anecdotal event concerns a cave on a high ridge running into the Fitzmaurice River in the Northern Territory. Fitzmaurice runs roughly east-west into the Joseph Bonaparte Gulf. After a lengthy helicopter ride with about 14 people in it, 2 anthropologists, a judge and an associate, and 10 Aboriginal people, we stopped on the top of this ridge, looking down on the ridge, which then rode into the Fitzmaurice River. There was only one Aboriginal who was with us, who was an elder, who said, "I want to show you something that nobody has ever seen before." None of the other Aboriginals in the helicopter had seen that place. We walked down a zigzag down about halfway down the ridge, and there was this cave, not quite as big as this room, but an immense cave, absolutely covered in paintings. And I'm sure it's not documented. There's no history of it anywhere else. It's still not recorded because it was confidential evidence. One of the anthropologists with us said, "If I die here and I die happy." There was just so much to see and interpret. So there is, and I wonder how much more there is to see and to learn of the Indigenous Australians. But we do know that they were here for many thousands of years before Captain Cook came along. And we do know a lot now about the strength and depth of their relationship, the Indigenous Australians' relationship with their country. It's a visceral, interdependent relationship born of a long knowledge, long understanding, and the corresponding responsibility of care and accountability to their country. It is amply recognised, as we all know, in the seminal decision of Mabo No. 2 in 1992. But back to Captain Cook. So we'll take slide 2. The Admiralty instructions to Captain Cook on his voyage to the Endeavour in 1768 to 1770 included direction to go to Tahiti to observe the transit of Venus and then to sail south in search of the great southern continent. There were secret instructions which he had, now held in the National Library of Australia, and you can see them here, including the following. You're also, with the consent of the natives, to take possession of convenient situations in the country in the name of the King of Great Britain, or, if you find the country uninhabited, take possession for His Majesty by setting up proper marks and inscriptions of the first discoverers and possession. As we know, Cook, after seeing New Zealand, travelled up the eastern coast of Australia, stopping in Botany Bay, and then continued north, mapping the coastline. And on the 22nd of August, 1770, on Possession Island, obviously named for a particular purpose, on the northern tip of what is now Queensland, he took possession of the eastern coast of Australia on behalf of the King. Cook had noted signs of habitation as he sailed up the coast, including fires, but we infer, perhaps kindly, he did not consider the habitation was in any sense ordered or structured. His diary notes that the Aboriginals lived mainly on shellfish and did not cultivate the land or erect permanent habitations on it. And he recorded the land as in a pure state of nature. Hence, apparently, the description terra nullius. History has shown that Cook was wrong. Just by way of a comparison of relatively contemporary events, the Treaty of Waitangi, which governs the relationship between European settlers and the Maori people in New Zealand, was made some 70 years later in 1840. But going back before Cook's voyage, the European settlement of what became Canada commenced much earlier. As you know, there were territorial battles between the French and the British, and with the settlers in what became the United States. The Indigenous Canadians often played a significant and strategic part. And at the completion of the 7 Years' War between the French and the British in 1760, 10 years before Cook planted the flag on Australia, the British entered into a treaty of what's called the Treaty of Oswegatchie with 7 Indigenous tribes centred around the St Lawrence waterways. And subsequently, as the settlers moved westwards across Canada, the British entered into a series of treaties with the relevant Indigenous peoples. The only province of Canada which is not the subject of treaty is British Columbia on the far west of the Canadian country. So the concept of a treaty on the part of the British was not unknown at the time of Cook's voyage. It did not occur in Australia. Although it's not necessary for present purposes to trace any specific history through the 19th century and up to about the late 1950s, we have to note that the history of colonisation progressively imposed the acquisition and use of property under the colonial and then Australian laws following the Australian Constitution in 1901. The progressive acquisition of such property interests at the expense of Indigenous interests in country and the consequent dispossession of Aboriginal Australians was not by consent, not their consent, and often achieved in violent circumstances. It's a history which must ultimately be fully exposed if there is a truth-telling inquiry, one of the 3 objectives of the Uluru Statement from the Heart in 2017. Many of you will know that the University of Newcastle, together with IATSIS, has since 2014 been progressively recording a history of colonial frontier massacres. And if you go to that website, you'll be able to see the progressive recording of those historical events. And that goes, it's a history which you'll find reflected in the famous speech by Prime Minister Paul Keating at Redford in December 1992, and later by Prime Minister Kevin Rudd in his apology in 2008. And you'll also be aware that there was some significant historical dispute about those events. On the one side, a very well-regarded historian, Henry Reynolds, who in 1981 published The Other Side of the Frontier about that history. At the time, his views, aggressive as they might have been seen, were called the Black Armband of Australian History by Geoffrey Blainey in 1993. And about that time, there was a period of what was called the History Wars, in which the principal critic of Reynolds' views was an historian called Keith Windshuttle, who regularly published in The Quadrant, that leftist magazine which you all know about, very conservative. Going back to the events, the stirrings for the recognition of Indigenous land rights emerged in the late 1950s, and it was at that time really that as a whole community we were becoming somewhat more and then progressively more aware of the Indigenous Australians reviewing the policies which had managed the way they were exposed to Australia and treated within Australia over many decades. In 1957, the NAIDOC, National Aborigines Day Observance Committee, was established to draw attention to the significance of Indigenous people. In 1962, they were given the right to vote in Commonwealth elections. They'd previously been given the right to vote in some state and territory elections, and this made it national. In 1967, we had the referendum, which you're all aware, which was supported by over 90% of Australians. There were two climactic events, really, in the 1960s, which brought Indigenous land rights to the attention of the public. The Gove land rights case and the Wave Hill walk-off. I'll talk a little about them. Those of you who know the Northern Territory moderately well, and I know there's some number of you who do, will know that looking up the map from the south, in the top right-hand corner, the Gove Peninsula is at the very tip of the Gulf of Carpentaria and the very far northwest tip of the Arnhem Land Reserve. Incidentally, about halfway down on the western side of the Gulf of Carpentaria is a place called Blue Mud Bay. There is another significant High Court decision which I'll mention about that in a minute. The principal settlement in the Gove Peninsula, right in that northwestern section, is Yirrkala. Just before the start of the 1960s, the Yolngu people began a crusade for the recognition of their traditional interests in land. And that crusade literally continues to this day. The Yolngu people comprised a number of clans, including the family name Yunupingu, which you would all know. It features largely in that history as the family clan. Their family clan is the Gummidge clan, one of the principal clans in the Gove Peninsula. Another clan in the area is the Rirajingu clan, which is largely the Marika family. Just as a matter of irrelevant interest, but interest to me at least, John von Duser, who was one of our judges in the late 1980s, gave a judgment in a decision in which the Marika clan, on behalf of the Gove Peninsula people, challenged the right of a Vietnamese company to replicate Aboriginal paintings in a carpet. So they were making carpets of Aboriginal paintings. And the decision was that they were not entitled to do so because it was an infringement of copyright. And when and if you ever get to the Adelaide Court or to the Northern Territory Supreme Court, you will see the three original exhibits, the carpet exhibits, in that case. Two of them are in the Adelaide Federal Court building and one in the Supreme Court of the Northern Territory. But that's really by way of aside. Going back to the history story, towards the end of the 1950s, when mining became of great interest in the Gove Peninsula area, that stirred up the Yolngu people. It was at the time a company called Nabalco, but that's changed over time to different names as it's been taken over. And it was proposed to And that area was, at that time, an Aboriginal reserve. It wasn't a grant of land to the Aboriginals, but it was an Aboriginal reserve which protected access to that country for Aboriginals only. It proposed through the Commonwealth the grant of certain mining leases to the Nabalco company for the purposes of mining. The Marika family, on behalf of their clan and the more general Yolngu people, submitted submitted to the Australian House of Representatives in August 1963 two bark petitions. That is paper framed by bark, and you can see one of them there. There's been a book published about the bark petitions in the last 6 months or so. They claimed, and this is quite explicit, that the Yolngu people owned the land from time immemorial and that it would damage their sacred places within the proposed leased area, and they protested against the grant of mining rights. In terms of formal expression of interest, that is generally accepted as the first formal expression of traditional Indigenous land rights. That led to a report of the House of Representatives Select Committee, which recommended that they be given some compensation if the leases were to be granted. Nothing happened. In 1968, the Gove Peninsula and Nabalco Agreement Ordinance, 1968, provided for the removal of part of the reserve to enable the grant of leases, and in 1968, those 3 mining leases were granted. And we'll come back to that in other ways towards the end of my story. The Yolngu people then challenged that decision in the Supreme Court of the Northern Territory. We can have number 4, if that's right. Is that number 4? Number 5 I want. Go back. Oh, I've got the numbers wrong. Go again. Yeah, that's it. Thank you. And I'll go backwards. I didn't have any particular slide to show you about that, but that is the Supreme Court of the Northern Territory at the time. Those of you who know it now know that they have a magnificent Supreme Court building. This one existed in the 1960s. It was subsequently, when the Supreme Court building was built, taken over by the Federal Court, and it's also the building in which the Lindy Chamberlain trial took place. And if you ever went into the basement, spent some time and considerable time in the basement of that building. At all events, they challenged the decision in what's called the Gove Land Rights case. After an extensive hearing, judgment was given in 1971 by Justice Blackburn, who decided that their claims to have traditional interests in their land were correct, but that their communal native title interests in land did not form and had never formed part of the law of Australia. There was no appeal from that decision, but that wasn't the end of it. And I'll come back a little bit to talk about the consequence of that decision shortly. In the meantime, other Indigenous people were also reacting to their circumstances. It is a sorry, and from the pastoralist viewpoint, an embarrassing position that Wave Hill Station, and indeed all of the pastoral stations in the Northern Territory, were for many years supported by extensive Aboriginal stockmen and Aboriginal families who, by prescription, were to be paid no more than 50% of the white stockmen. And that was prescribed by the ward's employment regulations, the Aboriginals all being under a ward arrangement at the time. Wave Hill Station was owned by the Vesti family, a very rich English family who also had the meat treatment works in Darwin and some other properties. They didn't pay their stockmen at all. Some of the records show one of the Aboriginal people who was involved in the Wave Hill Walk called us, treating us as dogs. They had sustenance and they lived in tents with no floors, and that was how they were expected to work for their lives. That had been a case for a long time. An inquiry in the 1930s of the Northern Territory government described the Vesties as ruthless. And eventually there was the widespread distress about this arrangement led to the walk-off. The Gurindji people claimed that their country, where they were, was their country and not the Vesties countries. And in August 1966, a little bit before the before the Gove Land Rights case, 200 Gurindji stockmen and their families, who were servants and other workers, walked off, and it got some momentum around the stations around the area. The leader of the group was Vincent Lingiari. Can we go back one? Thanks, yes. That walk-off lasted for 7 years, during which there was a lot of public attention. After the election of the Gough Whitlam government in 1972, he decided to grant them to acquire the land and provide a release back of the land to the Gurindji people. And there is what you know as a famous picture of him providing the land to Vincent Lingiari. But over that period of 7 years or so, there was a lot of public support and recognition of Indigenous interests in land. One of the very positive supporters is the famous Fred Hollows, who you know about. Another one was a writer called Frank Hardy. Those of you of my generation will know that his most famous book is called Power Without Glory, published in 1950, about corruption, political corruption in Victoria. But his book called The Unlucky Australians was published in 1986 about the strike and was provocatively in favour of it. And of course, Henry Reynolds. So that public support eventually got the momentum for the Whitlam government to act and to solve the problem. The same time, or just about the same time, in 1972, the tent embassy was set up outside Parliament House. And now back to the consequences of the Gove Land Rights case. In 1971, the Whitlam government in 1973 established the Aboriginal Land Rights Commission, a royal commission, to report on the recognition of Aboriginal land rights in the Northern Territory and related matters. It was headed by Sir Angus Edward, or Ted Woodward, who appeared as senior counsel in that case for the Yolngu people and subsequently became a judge of this court. It provided two reports, the first promptly in 1973 to recommend the establishment of the Aboriginal Land Councils, which exist to this day in the Northern Territory, and in 1974 to provide for recognition of Aboriginal land rights in the Northern Territory. It was limited to the Northern Territory. Incidentally, the assistant to Woodward, when he was doing his report, was a young anthropologist called Nicholas Peterson, who is, of course, now in Canberra. The Whitlam government also at that time, as we're talking about where the momentum was building, established the Department of Aboriginal Affairs. And then towards the end of the Whitlam period in 1975, together with Attorney General Lionel Murphy, they then introduced into Parliament bills to establish the Federal Court, the Racial Discrimination Act, the Aboriginal Land Rights Northern Territory Act, the Heriock Act, the Trade Practices Act. So a massive momentum of empathetic legislation. It was not passed by the time Whitlam was removed, but to the credit of the Fraser government in 1975, with the support of Bob Ellicott, who was the Attorney General. Many of you will remember him. And he also, for a short time, was the judge of this court. That legislative program was progressed, and most of, if not all of that legislation was adopted, somewhat refined, in 1975 and 1976. I want to talk now about the Aboriginal Land Rights Northern Territory Act, called ALRA, for obvious reasons. It provided for the grant of unalienated Crown land in the Northern Territory to Aboriginal people, absolutely. half of that land, or more than half of the land which was granted by the Act itself because it was Aboriginal reserves. So by the Act itself, when it came into force in 1976, the Arnhem Peninsula Land Reserve and land reserves on the western side of the Northern Territory and other land reserves were scheduled as Aboriginal land, and that meant that is owned absolutely, with one qualification that had to be developed, and that is how far into the sea, or whether it covered the tidal waters. That was what was happening. And where there was no Aboriginal reserve, there was a process for an Aboriginal Land Commissioner to conduct an inquiry to find out who the traditional owners were, and then to recommend to the Governor-General that that land be granted. The first Land Commissioner was John Toohey, who had been appointed as a justice of this court, and as you know, from 1987 became a justice of the High Court. There were 249 applications made under that Act for the recognition of Aboriginal land rights in the Northern Territory for unalienated Crown land. They've all but one been dealt with, and the one is now the subject of a reserve decision, so they will all have been completed very shortly. And broadly speaking, they've all been successful. Significantly, compared to the definition of traditional Aboriginal ownership or native title rights in the Native Title Act, the focus is current, that is at the time of the inquiry, current traditional ownership. So the point is to decide who at the time of the inquiry are the traditional owners, and the need to chase back connection to the time of settlement was not provided for. So it is in a sense a slightly easier hurdle to get over. Most of the reports of the Commission and the claims which were made were dealt with by about 2000. But then in 2008, the High Court decided the Blue Mud case, Gumana, and decided that a grant of land under the ALRA extended to the low water mark in the Northern Territory, that can be some kilometres, and also to tidal waters inland. And that revived or reactivated a number of claims because the tidal waters are very significant. There's a lot of fishing, there's a lot of barramundi breeding and so on, so that re-enlivened a lot of those inquiries. And it also meant that the area of land between the high water mark, where land grants or pastoral leases went to, and the low water mark, where the sea was coming in and out, could be, or Aboriginal land if it hadn't already been the subject of a grant, which meant access to the waters was also controlled, and there was quite a few frustrated or angry people who suddenly found that there was a grant they had, but technically the Aboriginals could control whether they could walk over the sand to get to the water. So it was quite a significant decision. Now, those things have all largely fallen into place, but the result of that is that a fraction over 50% of the Northern Territory is owned absolutely by Aboriginal people. So in terms of grants of land, that has been a very successful piece of legislation. And those grants are not like the Native Title Future Acts subject to anybody's decision to interfere, including government. They are just absolute and cannot be interfered with. So that's an important thing. The next thing there's the two other things I wanted to make the comment about with that. Like native title, when John Toohey started hearing these cases, or these claims, they weren't cases of course, because it was an administrative process acted on by the Governor-General and subject to review by, as it happened, the Federal Court. But for a sort of administrative review, Toohey had an anthropologist with him there would be a land claim, they'd go and talk to all the people on country, they'd make a decision about who were the right or who were the people. The issue really was, are there traditional owners? The Northern Territory would take the view that they're not traditional owners, and the issue was, are they traditional owners? And it was a relatively straightforward inquiry. Over time, the Indigenous people themselves became more involved in competitive environment, seeking to get land, my land, not your land, or Gurindji and Rirajingu were competing, or whoever, so that there was a lot more cross-competition when the Northern Territory more or less said, yeah, we accept that the traditional owners, you go figure out who they are, in a very competitive environment. And we've seen that also, I think, in the Native Title Act, that there's been a lot more intra-group or inter-family or intra-clan disputes about who the right people for the country were. The second is, I think, that involvement of family groups, clan groups, competing groups tends or might tend to show, and it has showed, I think, more awareness on the part of individual family groups about the significance of ownership in terms of its recognition and their interest in it and their accountability, the benefits of accountability for it. Just so that you know that no other states were ignoring this evolution. In South Australia, the Don Dunstan government passed the Yankunytjatjara Land Rights Act, which gave the Aboriginal people in South Australia the northwestern corner of the state, almost above the train line. And a few years later, the Maralinga-Jatjara Land Rights Group, which is the next group down under that to the railway line and to the coast, title to that land. The Maralinga land, of course, as you would appreciate, was that where we managed to allow the British to do their nuclear exploration for nearly 20 years. And in New South Wales, the Aboriginal Land Rights Act was passed in 1983, so other states that were responsive. Then we come to Eddie Mabo. And we go to number 7, I think, please. What a difference a man can make. You all know about Eddie Mabo, part of the Murray Islands, a Meriam Islander in the Torres Strait. Unlike Australia, those islands had never been occupied by European settlers in the same way as the mainland. His claim was made in 1982. What prompted it? Well, I didn't know this till I was doing some research for this paper, but at James Cook University in 1981, there was a historian working there called Henry Reynolds, and the gardener and groundsman was Eddie Mabo, and they were having a conversation. This is all recorded in a book of Henry Reynolds called Why Weren't We Told, published in 2000. So Reynolds and Mabo were talking, and Eddie said, oh, this is my country, and Reynolds said, no, this is Crown land, and Mabo sat back and said, this must be wrong, and that's how he got the momentum with Reynolds' encouragement to bring his claim forward. So he introduced his claim, and of course, as you know, it wasn't well received by the Queensland government. There had been a case of Kuata against Belky Peterson in 1982, when a proposed acquisition of the Archer River cattle station by John Kuata, who was an Aboriginal man, was opposed by the Queensland government because it wasn't appropriate for Aboriginal people to own that land. That was unsuccessful. Kuata was acting on behalf of the Wik people, whose Wik subsequently becomes a significant case in the future, which is in about the middle of the northern part of the Cape York Peninsula. Queensland also, at the same time, challenged unsuccessfully the validity of the Racial Discrimination Act as being beyond the powers of the Commonwealth, and they lost that. Then they tried a more direct way to block Aboriginal acquisition of land by passing in 1985 the Coastal Islander Declaration Act, which purported to wipe out any property rights of Torres Strait Islanders as at 1879 without any form of compensation. That legislation was also declared invalid by the High Court in Mabo No. 1 in 1988. And so Mabo proceeded with his claim thereafter without the impediment of Queensland. And of course, as you know, it was successful in Mabo versus Queensland No. 2 in 1992. That was when the concept of terra nullius was shattered. And if we can put it into a few unfairly simplistic propositions, the starting point is the Crown's acquisition of sovereignty in 1770. The High Court then had radical title to all of Australia. Indigenous land rights were nevertheless existed at the time and survived subsequent to any subsequent acts of the Crown. Subsequent acts of the Crown could extinguish, in whole or in part, the Indigenous land rights, but the Indigenous land rights which were not fully extinguished could still be recognised to have, provided they existed at the time of settlement and had continued to be practiced to the time when the call for recognition was made. So that really was a very coarse summary of what the High Court said in Mabo No. 2. And that led to the Native Title Act in 1993. As you know, the public and the media response to that enactment was mixed. Some of the media, the Sunday Herald Sun, screeched, "Mabo madness, we'll be losing our hills hoist from the backyard." But there was also considerable public support for the decision. And then Keating's speech in December 1993 was given to launch the United Nations International Year for the World's Indigenous People. And that really was a very strong momentum in support of the Native Title Act. The Native Title Act, of course, was a compromise. There were extensive negotiations. Frank Brennan's book is really a very good description of, because he was intimately involved in those negotiations, but on behalf of the Indigenous people, the principal negotiators were Noel Pearson, who was then the director of the new Cape York Land Council, Senator Pat Dodson, as he then was, and Marcia Langton, who was then a member of the Cape York Land Council also. And the Native Title Act itself spread from Queensland to Western Australia a sense of distaste for this legislation. Western Australia challenged the validity of the Native Title Act unsuccessfully. A decision in Western Australia versus the Commonwealth in 1995 upheld the validity of the Act. That's just called the Native Title Act case for obvious reasons, affectionately. Almost inevitably, then, we have a structure for that moving forward. The process of recognition of claims as traditional owners was slow. In the 1990s, much is explained by the need for the High Court to refine or define processes and concepts. The three main concepts in the Native Title Act, I suppose, if you simplify it again, are connection, extinguishment and compensation. And connection had those elements that I spoke about: existence at the time of settlement, which in practical terms meant the time of European exposure, and then the continuity of the community with their traditional laws and customs to the time of the hearing. The significant decisions in the High Court were Ward in 2002, after a very lengthy and complex trial which Justice Malcolm Lee of this court conducted. So he did the first native title full hearing. And then Yorta Yorta against the state of Victoria, also in 2002, which might be seen to have imposed a fairly high burden of proof to establish continuity. Then in 1999 we had Yamir, which the High Court said meant that the land grants could extend to areas, over tidal areas, and the areas of the seabed under tidal areas. So that reflects or anticipates what was said in the Blue Mud Bay decision. Finally, in terms of general principle, we had the decision of Akiba against the Commonwealth in 2013, a brilliant judgment of Justice Paul Finn, and then upheld by the High Court, recognising the traditional ownership of the broad Torres Strait Islanders in the land and waters of the Torres Strait, including the right to take fish and other resources and for using it for commercial purposes. And you might be surprised to know, but perhaps it isn't a surprise to know, that the entitlement to use resources of country for trade purposes was not routinely accepted by the Northern Territory until a decision of Borroloola in 2015. That was a single judge decision, but it wasn't taken on appeal. So traditional rights and interests can include commercial rights and interests. The Native Title Act was amended in 1998. I don't need to go into much detail about its terms because you know them. It refined or confined, or however you would like to describe it, the Future Act environment. It made some elements of proof a little more complex. But importantly, it recognised that the High Court, in a decision in Brandy against Heriock in 1995, needed to have the Native Title Act decision-making process restructured. Originally, the contemplation was that the National Native Title Tribunal would hear the claims for recognition of native title. They would do that in a very informal way and mediate it. Most of them, in anticipation, would be by consent, and the Native Title Tribunal could then grant the recognition. As a result of Brandy, it became clear that the Native Title Tribunal was exercising the judicial power of the Commonwealth. And so it could not make those final decisions. It could mediate, it could recommend, it could investigate, but it could not decide, because decisions about land ownership was a judicial function. And that is about when the Federal Court first really became deeply involved in native title. Up to that time, its function was really to decide issues of principle or complexity and then see what the High Court had to say about it at the end of the day. So we then had the function of hearing and determining all applications for the recognition of native title. And as I should have mentioned, because you probably all know this anyway, Bob French was at the time a judge of the Federal Court. He was the first president of the Native Title Tribunal until 1998. And then in 2008, he was appointed the Chief Justice of Australia. So that was the sort of rough process of the significant decisions. And the same process followed with respect to extinguishment. Under the Native Title Act, it provides that Crown grants of interest in land up to 1975 are valid and effective, and it extinguish the then existing native title rights to the extent of the inconsistency. FIJO, in the High Court in 1998, decided that freehold grants of land absolutely extinguished native title, so the Hills hoists were quite safe. Wick in 1996, you can move that one. Just go another one there. Wick in 1996 determined that pastoral leases did not wholly extinguish native title rights. So that was quite a significant decision at the time to preserve such traditional rights and interests as were consistent with pastoral leases. And in a sense, the main thing it extinguished was the right to exclusively control who could come onto the land. But other than that, mainly the traditional native title rights and interests could be recognised. And there you have a picture of Justice Cooper, Richard Cooper, who made that decision. If you read the Weekend Australian, what's the name of it? the female at Albrecht or someone like that, what was it?
Janet Owens.
Yeah, sorry. She was criticising people for being judges, for being part of the picture of the victory of the case. So Richard Cooper would have got another mention had he still been alive in her article last Saturday. So, and then much more recently, although it was always contentious, the High Court in Western Australia against Brown in 2014 decided the same thing about mineral leases and mineral grants, mining leases and mining grants, so that they do not totally extinguish native title rights and interests. So that apart from freehold grants, there is scope pretty broadly for traditional rights and interests to be recognised, at least where there are no absolutely extinguishing interests. Then we come to the topic of compensation. After 1975, the Native Title Act and the complementary state legislation provided that those acts up to the time of the Native Title Act, so 75 to 93, if they were invalid because they did not involve the payment of compensation, were validated, but there was a right to compensation, and that's where the Timber Creek and other decisions fit into that picture. And then from 1973 onwards, because there was the structure that existed, the Future Act process determined the extent to which native title rights and interests could be impaired. As I said, by way of contrast, the ALRA grants cannot be interfered with at all. I wanted to say just a bit more about the method of determining compensation. Do know a bit about it. Timber Creek was for the Nangawura and Nungali peoples whose country was affected by the establishment of a township of Timber Creek. Around the township of Timber Creek, there is Aboriginal Land Rights Act country. The High Court gave judgment on this decision in Griffiths in 2019. So the unlawful but validated acts were those which took place after 1975 and before 1993, mainly in the early 1980s, about the establishment of Timber Creek and then grants of interests within the township of Timber Creek. And they significantly affected native title rights and interests. Firstly, they extinguished exclusive native title rights. Secondly, they interfered with the enjoyment of those native title rights because of a number of ceremony grounds which were impaired because you couldn't have neighbours over the back fence looking at the ceremony and that sort of intimacy. And thirdly, they actually blocked a significant dreaming track, which was very well recorded. And and because of the remoteness of that country, there were two very senior men of that country who were responsible for the country and who had seen those things happen and had felt terribly guilty about them. So that the evidence, supported, I might say, by very impressive anthropological evidence, was of a very strong and persisting sense of guilt for what had happened and a sense of frustration about being unable to do anything about it. It was real. I had the privilege of seeing it. And these men were very distressed, and other parts of the community were very supportive of that. So that in terms of graphic evidence, it was clear that they felt very deeply and really felt deeply about the loss of that country. As you know, there were three or four points in that case, other than how much for loss for spiritual compensation. Firstly, the issue was whether you value the land that had been wrongly acquired at the time of the acquisition or the time of the hearing. Well, that was decided to be at the time of the acquisition. Secondly, and then you work out interest on that. Secondly, unless there is evidence which shows that had the money been available at an earlier time, it would have been invested in a structure that would have produced compound revenue. Simple interest was the appropriate way to calculate interest. Thirdly, because it was only partial extinguishment, the amount by which the value of the land would be reduced ultimately was 50%. It started out at 80%. The full court took it down to 65%, and the High Court took it down to 50%. But that's really a matter of momentum. But on the not much importance. On the important thing, the aspect of spiritual loss, all of the decisions in the High Court said spiritual loss is compensatable. And the award, which was in that case $1.3 million, was upheld. But it is important, when I come to make some concluding comments in a minute, to note the strength of that evidence, because it won't routinely be available in other compensation claims. Finally, just go to the last one now, I think. Keep going. Yeah, that's right. Finally, I wanted to mention Unipingu again. The Gove Peninsula, in this case, the Unipingo family on behalf of the Longu brought a claim very recently. So this is the Gove land rights case renewed for compensation in respect of those 3 leases in 1968. The claim is against the Commonwealth because the leases were granted when the Commonwealth was responsible for the Northern Territory. Those of you who know a bit about the Northern Territory history is that when it was established, it was part of South Australia, or administered from South Australia. That's when the train line was supposed to run from Adelaide to Darwin and never did. Got up as far as Erdnadatta and stopped. Then in 1911, South Australia gave the Northern Territory the Commonwealth, or the Commonwealth took the Northern Territory because it was a financial burden to South Australia, apparently. And the Commonwealth ran it until it gave self-government to the Northern Territory in, I can't remember the precise date now, but this period of time, up to 1968 at least, was run by the Commonwealth. And the argument is, Native Title Act provides for compensation. This land was taken away by the leases. Their interest in this land was dramatically affected by the pastoral leases, by the mining interests that was granted in 1978. The power which gave the Commonwealth to do that was the Section 122 of the Constitution, which gave the Commonwealth power over the territories. So the Commonwealth Act, which was passed, which enabled the grant of the leases, and the grant of the leases were therefore acts of the Commonwealth which diminished the native title rights and is there compensatable. And the Constitution at all times provided for the acquisition of property on just terms, and there were no just terms. So that, if I can oversimplify the decision of the full court in May 23, is to say those steps mean that you're entitled to compensation. The Commonwealth response is twofold. One, it says what we did under Section 122 is not subject to the provision 5131 in the Constitution that says you cannot acquire property without just terms, that they're unrelated activities. And the second argument is that 5131 in its terms does not provide to pay compensation for Indigenous land rights, but only land rights which are granted by the Commonwealth from the time of settlement. So they're the two positions of the Commonwealth. It was heard by the High Court in August last year, and the judgment is reserved. I don't know how many of you get it, but I get a newsletter from the High Court that tells us when they're about to deliver judgments. I got them, one came out on Monday saying we're delivering 2 judgments next Wednesday, which is 3-4 days away, and I thought, oh dear, it might make everything I say stupid, but it's not this. There are 2 judgments of the High Court coming out next Wednesday, but they're not this. At all events, that is a very important case. It will apply only for a a limited period of years when the Commonwealth was directed in the Northern Territory, but it will apply generally within the Northern Territory. Whether it can be converted into something more widely is moot, but probably not, because the states up to, except under the under the Racial Discrimination Act, which created, in effect, the right to compensation from 1975. Before that, the states could acquire land without being bound by 5131 of the Constitution, because it wasn't the Commonwealth's Acts. So probably it won't make a difference except in the Northern Territory. The claim is said to be for 700 million. It's only a number that's been thrown around, and the extent to which, if at all, the Yolngu people will have to give credit for the royalties they've received over now 60 years or so is it's an issue which hasn't been raised. How are we going for time? I've got a few minutes. It's interesting, I've said this before on other occasions. That wasn't the first planned compensation case, Timber Creek. The first planned compensation case was a claim by Django in and around Yulara. Yulara, of course, being the township that services Uluru and Katajuka. All of that land around Yulara is also Land Rights Act land, because it was unalienated Crown land which was given to the Indigenous people under the Land Rights Act. But Yulara, the township, and then the massive development that surrounds it with the airport and the hotels and everything that's there, is largely created after 1975. So theoretically, well, not theoretically, actually, if there are Indigenous owners of that country, the compensation claim was to be an easy walkover. And that's, as I recall, the processes at the time, the politics, that was what was contemplated. So Django was started out as a compensation claim, the first compensation claim, and then we will see how much money we will get. Well, as you all probably know, it went a bit off track, because in the course of the hearing, the issue arose about whether the claimants, the Django claimants, were in fact the right people for that country. It is inconceivable that at settlement there were not Aboriginal people who were the traditional Aboriginal owners of that land, but it turned out to be that in the course of that evidence, the Django people who were the claimants were not those people. And so the decision simply was claim dismissed, because you are not the traditional Aboriginal owners and you're not to be recognised as traditional Aboriginal owners. So that's how it ended up. And so Timber Creek, some 2 decades later, came up to be investigated. But it is a significant claim, and it doesn't make sense to say that there are no traditional Aboriginal owners of that land. So maybe it's a work in progress. Anyway, I'll get to the future issues, brief discussion, some of which I've anticipated. Firstly, there are still a lot of unresolved claims for recognition of native title. Those of you who are interested, the Native Title Tribunal has a terrific set of maps which you can access online, state by state, territory by territory, and Commonwealth, showing claims recognised, claims unresolved, ILUAs registered, and other grants in lands, and it's all nicely coloured so you can see all that if you wish to. And it's well worth a look. 2 issues again. As I've said, the focus more recently, both under the ALRA and under the Land Rights and Native Title Act, is to who are the traditional Aboriginal owners. Traditional ownership is not, as a concept, often disputed, but who are the right owners for the people is now becoming more contested. Sometimes it's a valid contest because there is a reason for it. Sometimes it's a valid contest because a particular person or family wants to be included and they're not included. This may become a more frequent problem or an issue because there are a lot more if you look at the statistics, I think 10 or 15 years ago, the Aboriginal community, people who recognise as Aboriginal in Australia, were a very small percentage, and now it's gone up to about 13 or 14% because people are much prouder of having the opportunity to recognise Aboriginal heritage if they want to. The criteria, broadly speaking, are the claim to Aboriginality and being able to show a line. And I think the cut-off point is sometimes said to be a 1/16th line. Secondly, prepared to acknowledge Aboriginal ownership or Aboriginality. And thirdly, acceptance. Now, there's no real reason why those criteria are necessarily right. There is, as I've mentioned to David Martin, a much greater trend in our communities now for people not to trace linear hereditary for the purposes of being able to speak for country. When we started hearing native title cases, we had father's line, mother's line, cognatic line maybe, and it evolved, and the court said you can evolve in response to community pressures and circumstances and so on, but you had to pick a country. Sometimes you would choose mother country or father's country, but you had to pick a country. Now nobody seems to worry about that. So I was speaking for this country here and this country here and my cousin's country over there, and so that the concept of linear inheritance of accountability and responsibility for country is becoming looser. And how that's going to pan out in terms of showing connection is an interesting question. How the court will address circumstances where there is a dispute about traditional ownership within groups or because of different groups is also an interesting question. Just again, an anecdotal case in respect of the land between Ceduna and the West Australian border in South Australia, the group that were claiming and were recognised as the native title holders refused to accept into that claim group a particular young Aboriginal man. He wanted to be recognised as an elder, not as an elder, as a member of that group, and they said, no, we don't know you, off you go. It just so happened that about a year later I was in Albany and I went to the museum that's there. I don't know if you've ever been there, but you can trace around it and you pull out a piece of paper and you follow the history of a particular person through the experiences at Gallipoli and where they were during the Second World War. It's a really excellent museum. Anyway, I pulled out a piece of paper and it happened to be the great-grandfather of this kid, young man, about 22 years old, who wanted to be part of this group. And the information was absolutely explicit that his grandfather fought in Gallipoli, he came from this place, he went back, he did this. Great. So that, you know, there's a great difficulty, I think, in courts being able to do the right thing or get to the right result in some circumstances where the complexity is there. So we've got that problem. The second problem is, of course, why there are so many contested avenues of entitlement to land. Because, as I said at the start, when John Toohey started out with the land rights ALRA claims, he had an anthropologist with him and it was a question of who are they? Let's just work it out. Now there's this one, and there was a claim under the Land Rights Act for the Cox Peninsula, which is the peninsula south of Darwin, a quite big area of land, where there were about 13 groups that wanted to be recognised as the traditional owners of the Cox Peninsula. And the Northern Land Council, who was responsible for deciding who they are in the first place, but as it properly doesn't, we just have to fund all these anthropologists who are all fighting with each other about who is the right people for the country. And sometimes one thinks, if it is such a science, why are there so many different answers? So that's really throwing a question in the air. The second thing I wanted to say is the strength of evidence, and I've made that comment already. I mentioned it briefly. strength of evidence, it applies also to compensation cases. The strength of evidence about connection is diminishing over time, diminishes because people don't inherit the stories, they don't inherit the songs, they're trying to reconstitute. David will be able to tell you, because he's been doing this work for many, many years, how close and obvious that strength of connection was. And now a lot of the ceremonies have ceased to be performed and they're not known. A lot of the songs are not known and people are searching for them. So the evidence about strength of connection is going to be diminishing over time, and especially for compensation cases, that will be a very significant issue. In fact, I notice in one of the Indigenous Times newsletters recently that one of the land councils is starting to seek preservation of evidence in anticipation of a compensation claim from the people who might do it. So I've got that issue. And thirdly, just as a general topic, either because of interest, and we have this in the Adnyamathanha people in the Flinders Ranges of South Australia, there is an increasing interest on the part of the people within the group about what's happening to the money. Some people say you shouldn't be allowed to inquire, but this is intra-group inquiries about what's happening to all the money that you've collected over the last 30 or 40 or 50 years, which we haven't seen any of. That family gets it, that family doesn't. So that's a problem that's evolving. And then externally, or more long-term and more complex, when and if compensation becomes a very significant amount of money, and it isn't compensation just for the present but for the future, how are you going to make decisions about how that money should be applied, how it should be managed, how it should be applied, and then to whom should you be accountable? Who should make those decisions? Because broadly speaking, I think it is fair to say that the 60s, 70s, 80s have led to a significant destruction of the elder management process, because a lot of the old men simply abandoned their responsibilities through drugs and alcohol and discouragement. And much more so, I think it's fair to say that older women assumed a greater role than they used to, and now the same problems arise. So they're things that are going to crop up in the future. I don't know the answer, I just raised the problems. My conclusion is optimistic. The initial fears for the recognition of the effective recognition of native title have been shown to have been wrong. The public awareness has developed to the point where, generally speaking, Indigenous land rights are strongly supported. And one needs to have been to a number of the consent determinations, which Darryl would have done and I've done a lot, and most judges have done, where the pastoralists and the miners are there saying this is terrific and they're really good workers and we really want to support them in our mining area, in our pastoral area, so that there's no reason to think that the federal court would not continue properly and effectively to determine those claims. The challenges that I've referred to are largely evidentiary, and they are going to be real. The threat is that they will not be satisfactory in terms of knowing how far you can go, how much you can infer, when the evidence is not as strong as it might otherwise have been. And the third thing is, let's see what the High Court says about Unipingo version 2. Thank you very much.
Sometimes it's very important when we face the drudgery of our everyday practices to take a step back and look at the bigger picture to understand how we got here and where we're going in the future. Thank you, John, for that very illuminating discussion. Please thank John Mansfield once again. We'll have a morning tea break now for 15 minutes, and please join us outside.
ready to go. Everyone was having such a lovely time at morning tea. We let it run a little bit longer than it was scheduled to. So what we might do is have this session go to 1:15 and then we'll have lunch until 2:15. In terms of this session, it picks up from where John Mansfield's excellent lecture finished up. That is current challenges with respect to particularly the resolution of claimant applications, but also the implementation of those resolutions, including PBCs. Its object is to encourage discussion about fresh approaches to known issues. As you will hear from Registrar Colbrand next, the court has received some, albeit not infinite, funding to assist in achieving that end. We have before you an eminent panel of speakers from diverse professional backgrounds who will give you the benefit of their perspectives on these challenges and how they might be approached. But what we're particularly hoping for is at the end, we have about half an hour left over for discussion from the broader forum. So the court is very keen to hear the broader group's views about what might be some innovative approaches to the issues we all know and deal with daily. Without further ado, I'll leave it to Registrar Colbrand.
Thank you. Thanks, Judge. And thank you all for attending today. It's wonderful to see so many experienced and known faces here today. The topic today, challenges, innovations and solutions in the native title system. Native title has certainly seen its challenges over the years, but we've also been fortunate enough to witness some excellent innovations to assist in progressing matters efficiently, effectively, and of course in accordance with the preamble of the Native Title Act. I'm going to just provide a brief overview today, focusing particularly on the challenges in the native title system. And at the end, as Justice Longbottom mentioned, we also would love to hear from participants and also from colleagues on the panel about thinking outside the box for innovations going forward in native title, particularly as the challenges that we face become increasingly complex, increasingly diverse, and the face of native title changes as we move forward. Just some statistics about matters that are before the court at the moment. We currently have 134 native title claimant applications, 6 compensation applications, 1 revised application and 5 PBC dispute applications. 2 noteworthy challenges that we see to the effective and efficient resolution of these claims are, of course, firstly, intra and inter-Indigenous disputes. These include disputes about composition of the claim group, the claim boundaries, and about post-determination control. More than 50% of the claims before the court have these types of issues before them. And as you know, often as claims progress, intra and inter-Indigenous disputes do come to the fore, and we do see more of them as claims that originally may not have had these issues. They do come about, unfortunately. And secondly is establishing continuity of connection of native title claimant groups to the area. About 15% of the current matters before the court have identified continuity of connection disputes or challenges that have been identified. While, of course, to many of you, these challenges are not new, they are complex and multifaceted and perhaps also exacerbated by the following factors. 1, the majority of straightforward claims have been determined. It's the complex cases that remain. And complexity can also be a reason that we don't see matters filed in the federal court. I know, for example, there is an area in the Territory where a decision has been made not to file claims precisely because of the intra-Indigenous disputes that do exist. Hopefully over time they can be resolved before claims are actually filed by the court. Secondly, there's a shortage of qualified and experienced legal practitioners and experts, particularly anthropologists. The lack of human resources does affect the quality and the timeliness of the material that we see before the court and the material that's exchanged by the parties. Of course, this type of material includes witness statements, genealogies, reports on historical aspects of the claim, and also anthropological opinion. It's also extending now in some parts of the country to tenure material, where we're also starting to experience delays in the collation and analysis of tenure material. As you know, all of these issues are essential for mediating and resolving disputes in native title and identifying those workable pathways towards solutions. In addition, the momentum gain in mediation can be lost without people available with sufficient expertise to do follow-up work, and it can be also further delayed waiting for people to become available. Another factor that does sometimes exacerbate these challenges is while we do see some innovation and parties are willing to take risks, there's also a number of others and another number of areas where there is a reluctance to try new approaches, and whether that be to, for example, approaches to evidence, whether it be to the way matters are sequenced in terms of the steps of the proceeding, or whether it be new approaches to mediation or case management. And this innovation is particularly important as we do see the face of native title changing and the types of disputes that are coming before the court changing as well. Finally, the focus of rep bodies is no longer wholly on native title determined applications. Rep bodies are also now turning their attention to activating native title rights of those who have a determination, including PBC governance and capacity, ILUA implementation, and commercialising native title rights. Resourcing and funding does, however, remain limited. Just returning to the figures in the applications before the court, the number of compensation claims filed does remain low, and the matters seem to fall into two categories: one that have been clearly marked for litigation, where people are looking for precedent, and others that are really heavily focused on mediation. Colleagues on the panel will speak more about the challenges in compensation claims. Disputes arising in prescribed body corporates are slowly increasing, and these frequently mirror the disputes that were apparent in the native title claimant process but perhaps were not resolved or were brushed under the carpet in order to get the determination in the first place. One thing that is interesting in the court, we are starting to see a lot of novel applications, which is quite interesting. Of course, you'll be all familiar with the KTLA application recently and decision of the court, which was the application to take evidence prior to the filing of a compensation claim. We're also starting to see a number of class actions, and one example of this is a class action brought in relation to the Aboriginal people in the south coast of New South Wales, where they're seeking damages for the asserted interference of the enjoyment of their cultural fishing rights, among other things in that matter. So innovations and solutions. The speakers who follow will no doubt elaborate on some of the challenges that I've spoke to, and no doubt they'll identify others. They'll also speak about the innovations they have utilised or might wish to try in relation to addressing some of these challenges. As Justice Longbottom mentioned, the Federal Court has allocated funding to the court in the most recent budget for case management and mediation of native title claimant applications. The funding is intended in particular to progress claims effectively and more quickly, to support First Nations economic development, and to support Indigenous directed initiatives. A significant portion of the funding has been utilised for the appointment of 2 new judges in the native title practice area, but there is also approximately $700,000 per year over 3 years remaining. That funding started on the 1st of January this year, and the court would welcome ideas or proposals for case management, mediation or otherwise in keeping with those objectives of the funding. Thank you.
Thanks, Nicola. Our next speaker is Rachel Kerrigan, who is the branch manager at the Land and Native Title branch of the National Indigenous Australian Agency.
Great, thank you very much, and thank you for the invitation to join today. Ahead of the session, the judges gave some very sound advice over what we should think about in preparing for the panel session today. One of the tips that was provided was that we should try and be entertaining, because that can go down well. I thought to myself, I'm a public servant and I'm coming to speak about funding and program administration. I'll leave the entertaining part to everyone else. Following on from Nicola, my comments today, my opening remarks will also be higher level, reflecting on the operation of the system as a whole, and particularly from the context of the National Indigenous Australian Agency as the agency responsible for the administration of the parts of the Native Title Act that go to the performance and functions of Native title rep bodies and service providers. So the 14 organisations that are funded across the country to deliver those services. I'd also just reflect that many of the points when we think about the challenges and some of the opportunities and innovations are similar to discussions that we have in many other forums as well. And so, you know, this is something that we're regularly talking about across the Commonwealth agencies that have native title or native title responsibilities. And so many of the people who are part of this committee are in the room today as well. But between the NIAA, the Attorney General's Department, the court, the tribunal, ORIC and IATSIS, we are trying to increasingly think about a systems approach to how we address some of those challenges across when we think about the pressure points and opportunities across the system as a whole. And so the reflections that we hear today will no doubt then inform some of our future conversations across those Commonwealth agencies and help inform our future policy and how we can kind of better streamline and resource the initiatives then to continue to address some of those opportunities. As we then speak about the increasing complexity of claims, it's also important to think about the ongoing impacts that has on the people who we all do this work for. And so the time it takes and the impact that has on elders and the potential negative impacts and lateral violence that can come and impact much more widely than the effectiveness of our institutions. As one challenge, that is one area that we need to continue to think about as we then think through what potential solutions and policy responses are. When I was asked to join this panel, it was suggested that I could touch on how funding for the system works. NIAA has powers under the Native Title Act to fund native title representative bodies and service providers to perform their functions. And at present, around $150 million per year is provided to the native title system through the Indigenous Advancement Strategy, the overarching program that the NIAA and the Minister for Indigenous Australians administers. About $130 million of this goes to native title rep bodies and service providers. And it is through these 14 organisations that government-funded support for native title functions is accessed. We provide this funding through funding agreements, generally up to 3 years in duration, while rep bodies and service providers provide operational plans that then detail what they expect to happen with claims at the beginning of the agreement in each financial year. It is then up to each of the organisations to prioritise the various work within its region. We don't interfere in the day-to-day work or the prioritisation of various matters, and whether a matter is funded and how it progresses is ultimately a decision of the rep body or service provider. But I do recognise they are making these decisions with a finite pool of funds, and at times do come back to the agency to then request additional funding. In reflecting on the challenges, and as Nicola has flagged, the remaining claims are increasingly complex, and this means they're increasingly unpredictable. Moving milestones, changes in approaches when Indigenous respondents join, and considering how to support different Indigenous parties to a claim are all factors that rep bodies are dealing with. And we know there isn't endless money in the system. This environment can therefore cause challenges for these organisations who need to continue to consider how to adapt to the changing journey of a claim. So we recognise the complex landscape, yet have we really made sufficient change and adapted in how we administer the programme in response to this? So funding continues to be provided and acquitted on a financial year basis. This can be a challenge for rep bodies as they allocate funds to priority matters and milestones then change and will be delayed from one financial year to the next. the government program administration side of things, building up underspends is not an efficient or effective way to then manage funds and carries risk around potentially reclaiming and redirecting priorities. So we need to be more flexible and adaptable in how we administer funding while ensuring proper use of public funds and meeting legislative requirements. We've made some changes in the most recent funding agreements to provide more of our operational funding upfront, so more of that 130 million at the beginning of the financial year and in the original funding agreement, so we don't keep the same reserve of contested litigation funding. In turn, we are looking for the rep bodies and service providers to reallocate and reprioritise regularly as claims and border native title work evolves, acknowledging again that expanding role of the rep bodies in terms of not just kind of getting a claim to a determination point, but then the role in the post-determination space as well. This is one small shift, but we need to continue to look at how we administer our programs and innovations to best support the evolving system. The other point I wanted to touch on today is post-determination. Complexity in claims can flow through. The diversity of views and issues that are present throughout the journey of a claim doesn't necessarily disappear upon determination. This creates immediate challenges for PDCs when they're then attempting to operate in the new environment. There are also some early determinations that are now seeing calls from groups to revisit. These calls can stem from how the determination operates in practice, and it can times intersect with the strength and the operation of the PDC. This will no doubt be complex as rep bodies and lawyers continue to navigate through. Capability issues and disputes within PDCs redirects resources away from other points in the system. So when you look at the system as a whole, we need to think about the resources that are being dragged away from progressing claims and other work into then supporting the issues that then are increasingly apparent within PDCs. PDCs are often established at the last minute, with quite rightly focus being on getting the determination done itself. Once established, PDCs are a new organisation and community, an organisation that is made up of traditional owners and those with the rights and interests, but the PDC has to navigate being a new organisation operating alongside existing community organisations. For complex claims, this balance of community governance while also ensuring strong corporate governance is potentially going to be an even bigger challenge. Immediately, PDCs are required to make decisions, yet with the focus on getting to determination and the PDC establishment at times being an 11th hour activity, this is not always set up for success. You can see this in the way that all books are developed and registered, with there being very different levels of detail around decision-making processes and how native title decisions will be made. There's so much opportunity for PDCs to exercise rights and interests and to realise a range of aspirations, whether it be managing on-country activities, negotiating with proponents, and then also noting the increasing calls on PDCs for their role in broader interconnected cultural heritage and other areas. There's of course challenges for PDCs in realising these aspirations, including the elephant that's always in the room around funding for PDCs. However, I think there's an opportunity and an area for innovation in how we can maximise our efforts in a system-wide approach into supporting PDC establishment early on in the process, and that flowing through to how a PDC operates post-determination. How can the research, mediation processes and other work through the claims process phase continue to be drawn on and also embed strong decision-making processes and governance for PDCs post-establishment? The determination itself is a hugely significant point along the native title journey, but it's not the end point. Our real opportunity for the people working within the native title system, many of whom are here today, is about thinking about how we best use the huge amount of knowledge and experience across the system to support then the ongoing journey of native title. Thank you.
Thank you, Rachel. Picking up on that theme of challenges faced by representative bodies, Susan, you've obviously got a depth of experience both by virtue of your role at NQLC and now currently at the Torres Strait Regional Land Council. Can you give us the benefit of your views about what the challenges are and what some of the solutions might be?
I can give my speech.
I would love it. That was my introduction.
Oh, okay, thank you. Sorry. Oh my goodness. Okay. My place on this panel today is to speak from the lens of the red body sector. And it is fair to say that this is a much broader lens because we are at the coalface of the native title system in all of its labyrinthic complexions. And my boss dared me to use that phrase, so there you go. For the past 7.5 years, I have been a native title rep body, and since February 2024, I have been with Gurra Abaradara Cod Sea and Land Council, also known as GBK. GBK may not be familiar to some, as it has only been the native title service provider for the Torres and Endeavour Straits since July 2022, taking over from TSRA, which had been the rep body for 25 years. GBK is not a new entity, however. It's had a significant role for many years as a peak body for Torres Strait PBCs, of which there are 23. It's had this role since 2012. GBK's board is made up of the chairs of the region's PBCs, and it has the unique distinction of being the only native title body that looks after the native title interests of both Torres Strait Islanders and Aboriginal peoples. We have an excellent website, which I would urge everybody to surf and find out some more information about the many unique things in our region. So my work as a native title lawyer, it's been so remarkably interesting and challenging, but there have been extremely tough times too. And certainly the threat of burnout is a real and present one for me and my colleagues. And this poses challenges in turn for the rep body sector. I'm humbled and honoured to have collaborated with the traditional owners of North Queensland, Cape York and Torres Strait and the Torres and Endeavour Straits on their at times long, frustrating, but never boring fight for recognition and a measure of justice for the wrongs of the past. Whilst at Cape York Land Council, I helped with the gathering of lay connection evidence for the Cape York United No. 1 claim, a massive project that covered a lot of my time there. And I think there will be speakers who will talk about that claim, which is such an interesting and innovative one. So I just wanted to speak, I guess, about some really important memories for me and to, I guess, explain the importance of the work that we all do in this system. So I have one especially tender memory of helping a witness, a much revered elder, with his 96-page written connection statement, sitting in his home with his wife and daughter at his feet, avidly listening to every word. Reading his statement one final time before he gave his approval took most of 2 days. And that's not talking about the weeks beforehand, getting to that point of that 96-page statement. There I was, holding back tears. His wife and daughter were openly crying as I read the story of his old daddy being taken by a crocodile whilst he and his brother watched from the riverbank in terror. And this beautiful elderly gentleman comforting me, of all things, patting my arm, saying, "Don't worry now, it was a long time ago." Whilst at NQLC, I helped with the first contested connection hearing in that region during the pandemic year of 2020. I fondly recall one of my clients informing Justice Collier when explaining why no women could hear evidence at a men's only side, that he didn't want a dead judge on his hands. On a serious note though, and with great sadness, I must say that 6 of the key knowledge holders from that trial who gave evidence have now passed. And that obviously speaks to such a serious challenge that we are all now facing. While proving native title is no doubt emotionally challenging, it's not strictly, I guess, about native title. In Queensland, where successive governments brutally and systemically interfered with Indigenous people's lives as part of a ruthless program of colonial dispossession, there are stories of profound and heartbreaking intergenerational trauma. Many Australians are unaware of these stories, and as a rep body, you will never forget them. And they also play into the disputation that so many of us have to grapple with when working on native title claims. So these are part of the stories that must be collated to support a claim. And now I'm going to speak to a particular thing that I think we could all do better. A burdensome challenge for rep bodies in Queensland, I can't speak to other jurisdictions, is the gathering of lay evidence to support submissions to the state government for acceptance of connection for the purposes of entering without prejudice negotiations towards a consent determination. Wow, what a phrase. Try unpacking that in front of a large meeting of sceptical native title clients. Only to be matched when you must explain the maps with all the Swiss cheese bits that will not be recognised due to extinguishment, or what it means to have native title partially extinguished, or that the other rights and interests will always trump your native title rights and interests that you fought so hard to achieve recognition for. Or after connection is accepted, but before final agreement, when you must spend a week on country in 40-degree heat getting yet more evidence, this time of occupation to revive native title over 97 or 98 long abandoned mining tenement land parcels. I must admit I didn't do that one. I had sufficiently advanced up the ladder to send out the claims junior lawyer and in-house anthro, but still. The enormity of the work running a native title claim cannot be understated. It is certainly not a simple case of breathing the antro, calling an authorisation meeting, getting through the reg test and rocking up to witnesses and asking for their stories. The reality is that there are months of work. There is the groundwork needed to build rapport with your clients. After all, they are asked to tell not just the lawyer, often a stranger, but also an unknown judge, the state, the respondent parties, their personal, deeply held confidential information. A huge ask. There is the job of building your client's understanding of and trust in the native title process, which is sometimes sorely lacking, and of keeping that trust in this extraordinary new age of online gossip, misinformation, and downright conspiracy theories. Not to mention the task of reading and understanding massive tracts of connection materials and genealogical charts and the early historical records. Who hasn't grappled with what Tyndale said or mapped over there and what Sharp wrote or mapped over here? And that is long before you even sit down with witnesses to start recording their evidence. So I'll get to my point. A significant innovation that I would like to see, especially in Queensland, is for the Queensland State Government to work with representative bodies to develop a more streamlined approach to the evidence gathering needed for assessing connection and applying the Section 47 suite. Many areas of Queensland that remain to be determined about existing determinations for which so much work has already been done. And I think that that should be able to form the basis for a truncated or short form connection assessment that is not so taxing of the rep body's strained human resources and for native title holders themselves. There is a model for this in the Northern Territory, I understand, and I urge for the Queensland State Government to look at that in Queensland. And this brings me to another challenge, and I hope that we can today explore some innovative ways of looking at this. I speak here, of course, of the delays and drain on resources caused by conflicts within or between claim groups, played out in expensive and traumatic respondent party proceedings and competing overlapping claims that all too often end in a contested hearing. Many of these disputes play out in the face of intergenerational community and family conflict that the native title systems seems to just more inflame. They are very, very difficult for the claims legal team to manage. I have a potential innovation or solution, and then I'll give you some examples of where I've seen it in operation. I'm going to use the phrase, and I don't really like it, but I can't think of a better one. Maybe somebody will help me down the track. I call it front-loading the claim. And by that, I mean excellent research into native title holding groups with a regional focus, followed by and building with a deep, honest and consistent engagement with your clients that ideally starts long before the claim is filed and empowers claimants themselves to negotiate and agree about boundaries and composition of the claim group and relationships with their neighbours. And now this might need, I guess, state government, especially the Queensland state government, to think about determinations without such a focus on language named single entity claim groups. For this front loading, what we actually really need are more skills around negotiation and mediation. We need to be able to communicate and engage clearly and effectively with our large and sometimes combative or seemingly chaotic claimant groups to build their understanding and consensus of the possibilities and the limitations of native title. Certainly, I feel that I have a need to grow my skills in this area. I'll give you an example now. I think that this was well accomplished in the Northern Cape and Torres Strait United Sea Claim Determination of November 2022, which resolved by consent a large part of 4 overlapping claims over an area of approximately 22,000 square metres of sea country of Cape York Peninsula and the Torres and Endeavour Straits. I can claim no credit for any part of it, but I'm aware of it because it is obviously within GPK's region, partly, and we provide support to the United Sea Claim PBC. So that determination provides for internal boundaries between Cape York Aboriginal native title holders and Torres Strait native title holders, and is underpinned by an innovative agreement between the groups that recognise customary rights. So in other words, while the determination does what it can do, which is recognise primary rights of a native title group, the customary rights agreement goes beyond these limitations and recognises the customary rights of the groups across group boundaries, meaning that what was and is in place under traditional law is enshrined in the determination and, most importantly, in the PBC rulebook. Getting back to Rachel's point, the work that was done in that matter to develop a rulebook that reflected the customary laws between the 4 groups of native title holders was a very important part. I would like to mention in this context and give GBK a plug, that since 2015 and long before it became the native title body, GBK has been running its own Indigenous-led model of negotiation called the Traditional Boundaries Project, and you can find information about that on our website too. So in GBK's region, disputes over who is the traditional owner of a parcel of land are common, and this project has been specifically developed to help with these disputes. It's an important feature of our work today, and go figure, communal native title is in fact a blunt instrument for the unique laws governing land ownership on the islands of the Torres Strait. From what I can see, GBK's Traditional Boundaries Project shares the fundamental character of Indigenous-led mediation and negotiation that was so instrumental to the success of the United Sea Claims mediation. And I've skipped a bit, so I just wanted to say that that mediation was a massive undertaking by the court, the lawyers, and the court is to be congratulated for its embracing of that Indigenous-led model of negotiation. And I also want to work that of course, the work of the applicants and members of the working groups in that mediation, their efforts can't be underestimated or understated either. So this brings me to my next and final challenge, being the post-determination world I now largely inhabit at GBK, and know to a friend and colleague who is still very much wedded to the cut and thrust of claims work, this is not the place where native title lawyers go to die. It is the work where claimants have the hard-fought right, but the heavy burden of resolving internal disputes, and then of distributing in ways that are fair and also preserving for future generations the benefits that arise from native title. It's a world of volunteer boards of directors with myriad and competing responsibilities within their communities and families, of people grappling with complex land tenure arrangements, especially in the Torres Strait, Oh my God, you should see it. Fishing licensing regimes, not to mention an international border and treaty obligations, and the ever-present and heavy workload of CATS Act compliance. So I will conclude. On innovations and solutions, it seems what I think is that empowering native title holders to negotiate and agree their boundaries and future relations as implemented in the United Sea Claims Mediation and the GBK's Traditional Boundary Project are not only important tools for the efficient disposition of the court's native title caseload, but for PBCs across the nation as they move into the future, navigating the complexities of the post-determination world. Thank you.
Thanks, Susan. As Susan mentioned, a success story in terms of the efficient resolution of complex claims is Cape York United. To give us the benefit of their views and some approaches that we used in that matter and are being used in that matter are Carla Cleese, who is counsel for the state, and David Yarrow, SC, who's counsel for the applicant.
Thank you. We would like to acknowledge at the outset that many of the things that we speak about are done in other matters, so many aspects of it are not unique. But we also acknowledge there are unique features of this claim that mean that not every solution or every innovation can be applied with a cookie-cutter approach to other claims. What we hope to do is, by giving information about what's happening there, is to trigger conversations about how these innovations may be adjusted or developed in a way that might apply across the country. I'm going to begin briefly with just a bit of facts about the Cape York United claim, because I don't presume that everyone knows about it. It was filed in 2014 as a single native title determination application over all undetermined lands and waters of Cape York Peninsula above the high water mark, but within the Cape York representative Aboriginal and Torres Strait Islander body area. What was left, so what hadn't been determined at the start of the claim was about 55% of the area of Cape York. It comprised about 6,000 parcels of land and an area of approximately 80,000 square kilometres.
In the spirit of collaboration, Carla and I will pass the baton backwards and forwards as we go through our presentation. So, innovation in action. I think we have some maps before an original claim map and a current state of claim map. Perhaps we could look at the original map, which will show you the claim boundary as filed. To date, there have been 27 consent determinations in the United claim for the benefit of 20 discrete native title holding groups. That's some 75% of the claim area. There's the original claim area, and there's the current, that's the original claim area with all the pink, no determined land, and then if we can flick back to the other one, the current state of claim area shows 75% of the claim area resolved. There have been some innovative forms of determinations along the way, some number of joint native title determinations where two or more native title groups come together to hold joint native title. There have also been some examples of overlapping discrete native title determinations. So, can I just briefly outline some of the challenges? The challenges are human, financial, organisational. Substantial time and resources was dedicated to the claim at its outset. Regional sub-regions of the claim had dedicated anthropological researchers that prepared sub-regional reports. The original trajectory of the claim involved a question about the level of land holding within the claim, whether whole of claim, sub-region of the claim, language identified groups, what have you. The claim was on a pathway to a separate question hearing when in April 2020, in something of a watershed change, the applicant and the state, in cooperation, approached the court to change the mechanism of resolution of the disputes in the claim to intensively case manage sub-regional areas that were separately timetabled, intensively case managed and supervised by the court. As of April 2020, there still remained doubt about the exact location, extent and nature of landholding groups and their the composition of those groups.
All right, we're going to talk about a number of innovations and solutions that are used in Cape United, and the first that David has already touched upon, we wanted to highlight is the collaboration. Even during the period where there was disagreement at that fundamental level, the two legal teams engaged intensively, lots and lots of all-day, several-day meetings in an attempt to find ways to move forward. It culminated in that agreement, as David said, in 2020. And I guess some of the features since that time that are worthy of elaboration is that there is an annual planning meeting that's conducted that looks ahead to the year to work out and balance resourcing on all sides. And every sub-area is heavily timetabled, and it is a, what's the engineering term? Where this one's happening here and this one's here, and so it's an intensive engagement where we plan in detail what's to come. Part of it is being realistic and have contingency planning. Where might things go wrong? What might happen? What will we do that can't happen then? And I think one of the benefits of the claim is that we are able to move things around. So if this goes pear-shaped, we can actually then front-end this area. And so I guess it's the regional approach and the collaboration in managing how we can constantly be progressing the area as a whole, even if some areas need more time, is an element of this claim. The other thing that happens is there are very regular online meetings, partly as a result of the intensive case management and preparation for the many, many case management hearings that are conducted. The legal teams meet and plan.
There's also ready and frequent and frank communication between legal teams and with agreement with the court. The judicial supervision involves not just pure case management hearings by the judge, but also regular supervision by judicial registrar grant. The parties are in regular communication with the judicial registrar, but also the parties, the representatives of the applicant and the state are frank and open with each other about each other's progress. So there have been many instances where, for example, in the process of developing a group description for a particular native title group, the state might say, here's a native ancestor for which we think we need more evidence, rather than every issue being in dispute. A focused and responsive approach by the state means that that particular additional piece of research can be given and agreement reached about a group description. On many occasions, there has been sorry business that has disrupted the applicant's progress, particularly where engagement with the group, the particular native title holding group is required. Being frank, open and flexible about limitations of time and resources. Both the state is sympathetic to the applicant and the applicant to the state of each other's accountabilities and needs for decision making. One fundamental strength of the approach in the United claim is what's been called the boundary identification, negotiation and mediation process. Her Honour, the Chief Justice has, on a number of occasions in reasons for judgment for consent determinations, referred to how it's been deployed. It's where traditional owners, in accordance with a court-mandated timetable, conduct their own meetings to decide their own group prescriptions, meet with their neighbours in appropriate resource ways to negotiate boundaries with their neighbours. These meetings are supported by experts. There's legal, anthropological, genealogical assistance provided, but the starting point is that this is a traditional owner process, and every effort should be made for traditional owners to make decisions according to their own needs. It's been highly successful. It's not been perfect. There have been occasions where agreement has not been reached as of that process, but the consent determinations to date and the volume and size of them bears out that it has been highly effective. It doesn't happen overnight. It takes resources, frequently multiple meetings on the boundary front between neighbouring groups, but also a group itself concerned with group composition. Frequent meetings that bear out a culminated boundary and group composition, group description that goes to a full group meeting for adoption. In every case for consent determination to date, those consent determinations are underpinned by the group ratifying the decisions that have been made about boundaries and group composition.
Yes, so I think we cannot deny there have been jointer applications. There, it hasn't always been happy families, but ultimately the process of Indigenous led engagement to agree boundaries and then going to the whole of the group to get endorsement has meant that both the state and the parties and the court and the applicant have been able to say, well, actually this isn't through this rigorous and long process, and the court has made determinations. So whilst there has been applications, ultimately they have not disturbed an impending consent determination because of the rigorous process that has led up to it.
Carlos just mentioned that there has been occasional disputation, and not just in the arena of the court. Sometimes there have been occasions where the boundary application negotiation process itself, has not produced agreement, and there has been an escalation of dispute resolution. On a number of occasions, that's been mediation provided by a registrar of court, but there have been some other more unconventional approaches to dispute resolution. One very successful way that has been used to produce agreement has been co-mediation, where the registrar of the court co-mediates with an Indigenous mediator. There's been the occasions for on-country meetings and dialogue between neighbours, particular representatives of mediation with a retired judge, including the Honourable Justice Mansfield. We've also used mechanisms of independent review and advice, presently contemplating a more sophisticated approach for independent expert evaluation. That's a bit of a work in progress. Achieving agreement with the state about connection proceeds in a staged way under the court supervision. The achievement of timetables, particular sub-regional case management timetables, was initially achieved only for those areas where there was in principle agreement by the state to accept connection. Not all of the claim area proceeded at the same rate towards consent determination. So there were initial timetabled areas. Those timetables required more detailed work to achieve actual agreement, not in principle agreement, actual agreement about group composition and connection. While in the balance of the claim area, more work was done anthropological in terms of preparing lay evidence to satisfy the state about in principle, to achieve in principle agreement about connection. Once that in principle agreement was achieved, that area then moved into intensive case management timetable. You can see how there's different stages of workflow management in front of the court, all supervised by Her Honourable the Chief Justice.
I think one of the strengths of the claim is that a linear approach hasn't been adopted. And so it means that for those areas where connection hadn't been accepted and more work was being done, often the group and boundary processes of the Indigenous-led grassroots interaction was occurring at that same time. So there was great efficiencies. There wasn't each coming back each time for different bits. Everything was being done at the same time. So that was one of the reasons why often there's a very quick turnaround once connection was accepted for some of those areas where it hadn't been initially, because all the other work was being done while everyone was out on country or meeting to get the evidence. We're going to speed up a little bit. One of the things I think we wanted to talk about that hasn't necessarily been used in the Cape York United claim, but there are practices we've become exposed to by some other innovative ways of thought it'd be worth mentioning it here as well. There has been what's called OSEC, or on-country evidence process, used outside the court, so without a mediator or registrar, but between the parties, going out on country and getting a bit of extra evidence to I guess, get over the line. There was agreement that that could be recorded, and if agreement couldn't be reached, that could be used as evidence. It wouldn't be wasted resourcing. The evidence could be used if ultimately you need to go on to a hearing. That's one innovation that has been seen. Another that I've been told about is the use of a preservation of evidence hearing, where there's been identified need to get it in relation to one witness. It was used a little bit more broadly to obtain further connection evidence in order to reach agreement. So again, it's utilising a process that was necessary and I guess piggybacking for efficiency of resources. There has been occasion where mediation has been used where claimants can directly speak and give some further evidence that might have been necessary to get over the line, so to speak.
So another example is grouping of respondents according to interest, and then segmentation of mediation, so the applicant can engage with a particular category of respondents in their interest category. A further example is geographical petitioning, particularly where consent determination is in more ready reach for a particular type of claim area. And no doubt, a partial consent determination for a claim at some level facilitates the resolution of connection with the balance of the claim area. And finally, approaches, and I'm particularly thinking of Victoria, prioritising mediation between the applicant and Indigenous respondents to achieve, can I say, an Indigenous arena consensus that then flows through and encourages settlement facilitation of resolving connection with the balance of respondents.
I think we wanted to end by saying that we don't want to be seen to be advocating necessarily that region-wide claim is a good idea. It's certainly not a panacea in that huge resource intensive, but I guess the concepts of regional organisation and planning and the concepts of then being able to move as different bits of work are delayed for different reasons and being able to slot something in might be worthy or able to be replicated elsewhere.
You might be surprised that I agree with Carla. What Carla described before as the ability to shift prioritisation, some degree of regionalisation, I'll say that again, regionalisation of a claim, whereby there is a palette that lack of progress in a particular area doesn't stall progress in the entire claim, and intense supervision by the court to ensure that everyone, all participants in the proceeding are accountable for the commitments they've made for time. Connection will be agreed in principle by state, provided you do it. That level of accountability in held to account in a very detailed case management timetable has been particularly helpful. I did want to end on a somewhat non-legal note. There is the unknowable quantity of the human factor. The relationship of trust and respect, the relationships of trust and respect that exist between particularly the legal staffs of the Land Council, Capital Land Council and Crown Law, the regular engagement with the registry and the assistance of Judicial Registrar Grant have been absolutely essential. And the sense of collaboration and joint enterprise amongst us all really has been a very rewarding experience. And it remains a traditional owner-led process, which we, the legal practitioners, and no doubt the registry staff involved as well, we are serving that traditional owner-led process.
Thank you. Finally, moving on from claim and applications to the post-determination space. Richard, over to you.
Thank you. Right. So Richard Abraham is my name. I'm currently a lawyer at Introductory, where I work mainly in the Future Act space. So my interest is in often what happens after the claim, but there are a lot of things that happen during the claim that impact on the work that I do. So I just want to touch on some of those things. Prior to going to Minters, I was at Crown Law, and it's great to see so many of my former colleagues here from the claims team, and I still remember the best advice I ever got in native title was from Christy Snake. When I turned up to her room, I think for about the umpteenth time, she said, "Richard, just read the Act." I often think of you because of the request here. I'll take it on. And there's a lot in that Act, you know, it's amazing. The last time I was here was, I think, fair to say, an unmitigated disaster. It was a joinder application to a native title claim for and it's humorous, okay, so please don't think something bad's happened. One day my client came to join the claim, and so I appeared before Justice Rangier to make all that happen. Of course, I messed up my appearance by not mentioning my client. I forgot to read my affidavit, and I didn't have a draft order. So the three things that you're meant to do, I didn't do any of them. And you were very kind, and I offered that kindness. And so I just want to acknowledge that.
That's why you're great counsel.
I better get your card. The Future Act space is sort of interesting at the moment, not least of which because we have the Law Reform Commission review into the Future Acts aspects of the Native Title Act. And that, as I understand the process, we'll deliver a final report by the end of this year, and submissions are currently open. So I encourage people to participate in that process. When I look at the terms of reference, one of the things that's mentioned there that sort of struck me was that fairness is mentioned, and it's not something you often see in legal documents, particularly around law reform. And I think that concept of fairness is really important in the Future Act space. And in my experience, and I'm speaking from my experience, it's not a Minter view, it's not the view of our clients particularly, although some of them share these views. I think there are some elements of unfairness in the system, and I'll talk to some of those now. So I think this is a great opportunity for us to take this Future Act, regime, to a different place with all of the learnings that we've had over the last 20 odd years. So, look, three challenges that I wanted to sort of focus on, and I'll just talk about what each of the challenges are. And there's nothing new here. All these challenges are listed in the discussion paper that's been put out by the Law Reform Commission, and all of them have been spoken about here by others. But these are the ones that really impact on me, and that I think are important to think about. I'll talk a bit about what those challenges then do, and touch on, I don't know if they're solutions, but more commentary, things that we might think about as we go forward here. So, look, PBCs, when we're dealing with a Future Act, we engage with the PBC if there's a PBC in place or an area where native title's been determined. I think, other than in particular cases, PBCs are generally under-resourced and don't have the capacities that they need. This is no criticism of PBCs. This is a systemic issue from where I'm sitting. They have a primary role of representing the interests of the native title holders. That is their job, and that feeds straight into the Future Act process. And from where I'm sitting, I'm not sure that they're fully resourced or have the capacity to do those things. Now, it's great to hear that there are things being done to fix that. I think some of the initiatives, Rachel, you mentioned are going to help with that. But we need some element of coordination around those things. So just to sort of go back a step and work out, why does this sort of matter? Negotiations can be incredibly frustrating for everybody, not just for the proponents who want to get their project up and running, but also for the groups themselves. The people who are on the PBC, who may well have just been thrown in without a whole heap of preparation, for the native title parties, or the individual native title holders represent as well. It's very difficult to negotiate effectively in that sort of environment. Opportunities are missed. The burden that's placed on individuals within the PVC is unsustainable often. Susan, you mentioned that, but the burnout and the level of overwhelm is hard. These people have day jobs, they have other things they need to be doing, and they're not always just there to help us progress our client's project, which we need to keep in mind. The agreements that sometimes come out of such a negotiation, I think are sometimes not really suitable. If you haven't been able to have a meaningful negotiation, then how do you end up with an agreement that actually meets the needs of all the people who are at the table? And then the other thing that happens inevitably after the agreement is signed and is in place, let's say it's an EUA, the implementation of the benefits, the ones that are not just the payment of money, generally fall apart. In my experience, I think of a couple of examples where things have gone to plan, but the vast majority of cases, you did a 10-year review after the signing of the EUA, most things have not happened. And a lot of that is because there's not the infrastructure and the capacity on the ground. So I think, what all of that says is we need more funding. It's not just about throwing money at things, but we need more funding to deliver capacity. And we need to ensure that these PVCs are not new when the determination occurs, that they are established and have those capacities in place from the moment they need to start doing business. How that works, I'm not sure, because the reality of claims is that everyone races around trying to get the claim up, and the last thing that happens is the PVC, and we've touched on issues there. But I would like to see that rethought so that PVCs are established prior to having to commence work. And look, there's some initiatives. I've chatted with Tim Wishart briefly about this. I'm aware of the People, Place and Partnerships program that QSNDS is running. I think it's sort of a pilot, which seeks to, and whether it's done through this sort of project or program or otherwise, seeks to talk to the groups who are going to be the native title holders, understands what their aspirations are, understands how they actually work, understand how the traditional law actually works on the ground, and then set up the PVC from that place, rather than getting a vanilla PVC and then having to retrofit all this stuff down the track. Now, we obviously have a lot of PVCs that have been set up vanilla, which probably need some retrofitting. I'm not quite sure how that happens, but let's at least, going forward, try to get the new PVCs set up on a more appropriate basis. There's obviously lots of work and lots of been done by all the various agencies around the place, and for that to be coordinated and led by what the group says is important to them and how they want to do business, I think is key. So that's sort of the PVC sort of funding type thing, which impacts on negotiations. The other PVC related issue is in relation to native title decision making processes, and that's been spoken about by a number of the speakers. There are, in some instances, intra-group disputes that are being resolved in the background while our clients are trying to secure consents or secure an EUA, and what do you know, it doesn't end well for anybody, and that leads to delays in timeframes and those frustrations that I mentioned before. So look, there's obviously some determinations out there where which actually reflect the boundaries within country that are held by various clan groups. And those, I think in the case of one determination I can recall, was actually a map, and that map then found its way into the rule book, and so it's crystal clear who speaks for what country.
I I think I know about that map, and I took that map into that community one time, and never, never, never will I take a map. Especially from like a 30-year-old determination.
It's a very hard to read map too. I mean, the photocopy I've seen is really, really faint.
Exactly.
Yeah.
No, it's just that some people's understanding of what the determination, especially these determinations that are 20 odd years old, you know, it's that ongoing education that is needed in the system as well for people to recall and understand what has been determined and what their rights are.
Absolutely.
Yeah.
And I think if that sort of, if it was informed by the, you know, from the group up, then, you know, a map might be part of it, or it might not be. It might be, but at least there would be some framework which people could operate in. And I think that's that makes for a very difficult negotiation, makes it very hard for both the native title parties and the proponents to get business done when there are those disputes, you know, within the group. It's a massive issue.
It's bright lines on maps. It's just, it's not traditional law and custom actually, and it, can be very disruptive. Yeah, but of course.
The United Sea Claim Agreement, is that public?
Yeah.
I'm really keen to look at that because that sounds like a really.
I'm not sure about the customary rights agreements, no, but definitely the determination reflects that.
Yeah.
Yes, that's another interest.
So to wrap that, it's from a proponent's point of view, you know, things work a lot better and everybody gets better outcomes if the decision-making processes are robust and understood, and the proponent is not the one sort of throwing the hand grenade into the group because they've turned up wanting to talk about business when the group is not ready to do so. The third thing I wanted to just touch on, which is sort of increasingly impacting the work that I do, is around compensation. So, you know, my note here is resolution of native title compensation under the NTA is yet to meaningfully commence. You know, I think that's probably a fair assessment, particularly when you look at past Act compensations. This is the compensation for the various acts that were validated by the Native Title Act. And the Future Act compensation, you know, under things like 24KA infrastructure, you know, for the general public, where the compensation is sort of kicked down the road to some future time, you know, to be resolved. So groups are sitting there saying, well, look, you know, we've had this act for 30 years. Business has been done in our country for even longer than that, and we've not seen a cent, not 1 cent. Future Act stuff is fine, but for the big past acts, the big mining projects that are pre-NTA, not a cent. So quite understandably, a number of groups are coming to us and our clients now and saying, well, you're here in front of us with your project. We would like you to pay for that. We know it's not your responsibility, but we want to pay because you're the ones who want to do something and we're not seeing any real action elsewhere. Now, you know, what it ends up looking like is things that were traditionally sort of heritage agreements, you know, where people get paid an hour for service for turning up doing heritage surveys, now loyalty arrangements, you know, which is more of a traditional native title type payment. And they do seek to sign off on full and final satisfaction of compensation in respect of the associated, you know, past or future acts. So things are moving, but my concern there is that it's not the most effective way of doing it. And the states and the Commonwealth are not at the table, which may suit them. I don't know. But I think we need to do more and think more about compensation and how we actually make that work through the system. Because there is jurisprudence that is required to inform the compensation negotiations. At the moment, negotiations are occurring almost in a legal vacuum. We don't know what the heads of damage are, we have Timber Creek, but we don't have much else. We don't have anything that talks about mining leases, for example. We don't know a huge amount about how you value the impact of those acts on native title. We've got Timber Creek once again, but that's all. It only deals with a limited set of circumstances. So we need more to occur, I think, in that space in order for that process to work through. And look, to come to the fairness point, I don't know anyone who would be happy, having had their house repossessed 30 years ago, to still be waiting for a cheque. I certainly wouldn't be. So, what do we do about that? I don't know.
Marching on Parliament House.
One thought I had was for there to be some sort of interim payment scheme where native title compensation, a base level, is paid to the people who are ultimately going to get it before they have to go through the whole process of a native title claim. That would have the benefit of building some more trust in the system, certainly would make it fairer. It would provide resourcing for native title parties to be getting on with the business that they want to do. It would obviously need to be, there needs to be some sort of streamlined process, I think. I can't see 300 odd contested native title compensation claims working their way through the courts. I mean, it's just all being progressed individually. The sheer workload around the tenure is almost is in some cases almost too much. So we need some sort of process for actually supporting the claims, and then some sort of post-determination adjustment mechanism, so that if a particular group was to establish a particular level of cultural loss, for example, above and beyond what might be sort of normal, then there would be an uplift mechanism for additional compensation to be paid. So like an incremental approach, rather than you've got to go through the whole thing before you see a cent. I just wonder if there is some way of a transitional payment type arrangement that might deliver some benefits and get some fairness, back into the system. Final, this is not one of my points, but the compensation really worries me, in the sense that, while in this room there is, understanding and acceptance of, native title as something that is appropriate and that is well, I know maybe it's not even appropriate, but we know why we are here. We know that the thing that we are trying to, address, and the interests that we're trying to protect. I don't see that out in the general public, and I have a real concern that if there are vast sums of compensation being paid, that is going to blow things up. And so it's beholden, I think, on all of us to be getting out there, trying to inform those discussions. And last year, I actually went on the radio. I was on 4BC. Don't anyone hear me? Sophie from Riker rang and said, look, the Gubby determination's just come out. We've had a whole heap of crazy talkback. Would you mind coming on and talking for 20 minutes about what the claim means and what it does not? And it was good fun. Clearly, from some of the comments afterwards, I didn't make any headway whatsoever in educating people. But I think there's a lot more work that needs to be done on that. So I'll just leave that. I would really encourage everyone to be getting out there, to talking to journalists in particular. They often say to me when I ring them to say, that thing you wrote was rubbish. I said, well, no one will talk to us. Who are we meant to check with? I do reply with, well, you probably shouldn't publish it until you have checked it, should you? But they deadlines and so on and so forth aren't being what they are. They just go ahead and sort of do it. So yeah, make a new journalist friend, I say to everybody, and let's try and get some of the more appropriate messaging out there so there is understanding, because this compensation thing is coming, and I don't know that I think there's a lot of people out there who will not be able to handle it. It will blow their minds. So, all right, I'll leave it on that.
I'm now going to open it up to the forum. This is a really important and somewhat rare opportunity for the court and practitioners to collaborate together about how we can do better in this space. So, certainly from the court's perspective, we're very keen to hear the broader forum's views. Do we have any volunteers? Kevin.
Is this on? Can you hear me? Look, thank you for that wonderful sharing of information and knowledge and experience. I think when we look at a system, we need to think hard about what is the system. It's more than the sum of its parts. It is the interrelationship of those parts in the pursuit of a common objective. And I think, to go to Richard's point, what is the common objective? What is the narrative that we are speaking, that we believe as parts of that system adhere us together? And I think the value of fairness is probably one distillation of it. So thank you for raising that. And I know that the ALRC in its review is looking at that concept. I love coming to forums like this because it's a good opportunity to see people that you haven't seen for a long time. And it's an opportunity to reflect upon how many times we've seen each other in different roles. And I think the challenge of the system is for the system to actually think of ourselves as a system, concepts of collaboration, things are happening at a micro level, at a claim level. That kind of experience and relationship needs to be telescoped to a macro level for the system to be sustainable. And to get back to the point of coming together, John Mansfield's wonderful erudite explanation of the system was fantastic. But we have elders, and I would say John is an elder of the system. There's obviously our traditional elders that are elders of the system. There are knowledge holders like Lee Sackett and David Martin here in anthropology. Sooner or later, if our narrative is not system-based, how are we encouraging people to enter this system? Because it's in that vortex of misinformation and disinformation that we will have a challenge to recruit to this system, to develop it, so this in rem, in perpetuity system has the capability to function. So some of the things that I see about, the opportunities is, look, John raised it this morning, it's the preservation of cultural knowledge is critical. There is the Attorney General's Department has taken leadership in that front with a range of stakeholders in the system around preservation of evidence. But it's more than preservation of evidence, it's actually preservation of cultural knowledge, so that we are not responding, so that people are not responding to when the next Section 29 notice hits. It's actually groups sitting down and planning and preserving their knowledge. And I don't have a problem with maps. Coming from the tribunal, I'm a firm advocate for maps. But maps are critical ways of archiving information. It's actually how you use that information. And we have 50 years of the land rights regime soon from the Northern Territory. We've got 30 odd years of native title. There is a wonderful archive of information. Some of it's wrong, some of it's right, and some of it's in the middle. We cannot afford to go back to square one because the resource constraints hit us all. So we need to be innovative around how we utilise the archive and also the knowledge that we currently have, because we are losing it. We're losing that from a traditional knowledge perspective, but also within our respective sectors. So it's conversations like this, and I commend the Federal Court for having these conversations, but we will go back to our sectoral vortices from this meeting and get churned around until the next time we pop up and have a similar conversation and we say, we had some really good ideas back 12 months ago. We've really, as leaders in this room, it behoves us to do something about that. And so I would be commending the challenge for the system, not within the system, for the system, is to look at strategic ways to build that narrative, to build a new system for the future. That's how we're going to encourage other people into the system. That's how you'll get succession into this area, whether it's anthropology, law, and indeed, as an Indigenous person, I would like to see our PBCs develop their own develop their own capability, so that there's they can plan not in a proactive way, but in a way that actually deals with the current issues that are in front of them, but also into the future. And Judge, I don't know whether I had a question in that. That's my 2 bobs worth.
Fabulous. Thank you.
Should have been a speaker.
Registrar Colbrand mentioned a case, and I just wanted to talk about the class action stuff, which I do through the native title. So the fisheries case in the South Coast, interesting because they don't actually have their native title rights yet, but we've started a case really in relation to all the prosecutions. But what I wanted to say was really to think about how there are other vehicles out there that can assist your clients in prosecuting or accessing their rights. And one of the cases I've thought about for quite a while in that class action front is the impact of, for example, environmental contaminations on native title rights. We would probably all be familiar with those PFAS class actions, have in places like Catherine, for example, where property holders were compensated for the impact of PFAS on the value of their land. Well, we know that there's around Catherine there is a native title claim. I did the referee report for Justice Lee in respect to Jarvis Bay and the impact of the contaminations there in that class. So, there is a real opportunity to use perhaps other vehicles, through this court, class action regime being one, to prosecute or to be able to effectively enforce your rights in other through other means. And so, some of the young players or new players or old players in the room who, yes, we are caught up in the day-to-day and we're swamped by the day-to-day, but let's also think around innovation and what can we do to perhaps extend or effectively entrench some of those native title rights which often get treaded over. So thanks.
Thanks, Josh.
I just wanted to speak as a native title claimant. We got our consent determination in December. I started in 1998, and we've lost a lot of people along the way. But just from the point of view of a Murray person who commences this journey of native title, it's a very stressful journey. It's a very tough journey. And at times you even have to stand up in front of your own people and cop some of the stuff that comes through. So when people here were talking about mediation, that's a great thing to have. But I think for us as a people of this country, healing is the first thing that needs to happen, because I don't believe people can come and mediate until those internal hurts and pain and anguish are addressed. So I'd really like the people in this room to think about where does healing, and whether it's the Healing Foundation gets involved, but for people to be able to sit down and come to the table and talk about their pain. I know within my own family group, in our area where our claim is, a lot of people were removed and taken to Woorabinda and Cherbourg and Palm Island, but there are other families who remained on country, albeit with the patronage of property owners who used their labour. But there was tension between those two groups then of, oh, we were taken away, but you stayed, so you must have sold out. So they're the kinds of things that we all need to be mindful of that's going on. I really like the idea of encouraging and bringing forth our young people into the native title space, because they are the ones who'll take over and they'll lead it. So what Josh was just talking about, I support 100%. And I'd just like to say, to put on record, I suppose, my thanks to Queensland South Native Title Services for the way in which they worked with us. And it wasn't easy, and there were hard times there, but they stayed with us and they stayed the journey. And now we are going to reap the benefits of that. And I think the one other elephant in the room for me, and I know it's not part of native title per se, but cultural heritage. That's where a lot of the arguments and the fights and the disagreements come about, is because of cultural heritage. So I'd like people to have a think about how to address some of the things that arise with that. And, you know, when we're doing the healing or the mediation for ourselves, where does that cultural heritage element sit in there? Because you know, a claim's put together, a group of applicants are found, then all of a sudden it's the Section 29s and the responses to proponents before the connection stuff is even done properly. And I'm sure people in the room know what I'm talking about. So just from the point of view of a person who's been on this road, you know, 27 years, to finally arrive at a point where we could look at it and go, we've been accepted by the courts, by the state as the traditional custodians for this land. But I take it back to my old uncle who said, and he's long gone now, he said, I don't need anyone to tell me where my country is because it's in my heart. So thank you.
Thank you very much.
I do have a question. What are some of the ideas being bandied about to try and speed up the process for the production and analysis of tenure materials?
Who particularly is your question directed to?
Anyone.
Anyone.
We could ask the Queensland State Government. I mean, they're the owners and the holders of the information, and I believe that there have been some moves to consolidate information about past acts, but I'm not aware of any. And we have a new state government now, of any urgent initiative or policy that's actioning that in a way that is helpful to the sector.
Is there anyone here who's able to speak from the perspective of the Crown about how tenure processes work and can be made more efficient? I'm looking steadily in that direction.
I guess the Department of Natural Resources as well. I mean, they're probably more, yeah.
And if there's someone who wants to talk offline, more than happy.
Sorry, it's Sally Davis over here. I, in my day-to-day work for AGS, we have a national practice, so we often see what things are doing. Obviously, our wonderful friends in Queensland. But just to give you an idea, one of the questions of what's being done to speed it up, I'm not sure if there's anyone here from Victoria, and obviously the Commonwealth has a pretty easy job. We don't do tenure, so I can't actually pretend that we have a large scale about this, but one of the things in Victoria is that a lot of their consent determinations now are having generic clauses in them where we don't have schedules attached to them listing all of the acts, for example, by lot and plan reference, or here's this reserve and that, because actually tenure is sort of left behind the scenes more and more is concentrated on finding recognition. So first it's, well, generic schedule. If your area is within one of these sort of a PEPA provision of the Native Title Act, then it's going to be outside of the determination area, but it's not actually specifically enumerated. So tenure in that sense, from a Victorian perspective, just to give a kind of that as one example, doesn't actually feature much. You don't get the timetabling there, for example, in the courts, which would list all of the steps that you might see in other jurisdictions about tenure analysis, exchanging positions, and a lot more is concentrated around recognition. So a lot more is done on the Section 47 suite, and in particular now Section 47C. So one of my observations from the system was really about learning from all of the other jurisdictions and really commending opportunities like this to be sitting down and seeing actually how really differently, in fact, it is actually done. Clearly, groups have different aspirations. We can't pretend, I think Carla said before, cookie cutter approaches don't quite work, and clearly not pretending that they do. But there's a lot of different approaches, even if within the one jurisdiction, which in theory is a national practice. But a lot of different approaches on the ground, obviously, through state levels and then federal levels as well.
Look, I'm conscious of the time, but I think, Kevin, you struck on a really important point about the need to have systems. We've heard a lot of discussion and good ideas today, but the important next step is to put in place systems that will filter those through and have a positive effect. I think to that end, the court is interested in setting up a user group where we can channel these ideas and see how the court can work collaboratively with all the parties who are engaged in this space to see what we can do to make things more efficient. It would be good to know if there is interest on the part of those who are here in that kind of user group being set up. Yeah, okay. Okay, then, well, and do you have it, Susie?
I was just going to make the comment that any user group that's established needs to have native title holders and claimants as part of it. Yeah, so acknowledging your point.
No, okay, no, well, that's a very sound point, Susan, and I think, we'll take that on board. Well, thank you very much for this, and thank you especially to the panellists for the excellent presentations for the session. Thank you. We're off to lunch.
Thank you. Everybody please take a seat. Well, good afternoon, everyone, and welcome back. I hope you've been enjoying the forum so far. My name is Bernard Collier. I'm a judge at the Federal Court, and I'm very happy to be here this afternoon chairing this session. Can you all hear me? The importance of independent, high-quality expert anthropological evidence in native title cases can't be overstated. So often in native title cases, the cogency and lucidity of the anthropological evidence put before the court will determine not only the outcome of a native title claim, but the path to determination of that claim. However, the very different nature of the disciplines of anthropology and law can result in tensions arising in the application of anthropological research in legal claims. This afternoon's session addresses conflicts which can arise between lawyers and anthropologists in native title claims, and perhaps more bluntly, the mistakes lawyers make in briefing expert witnesses. We have 3 eminent speakers for you this afternoon. Our speakers have promised to give time for your questions at the end of this session. I look forward to your questions then. If you can hold your questions until the end, please. In the meantime, please welcome our first speaker. So we are joined by, first, I'll introduce our speakers as they are giving their presentations. I'll introduce Dr. David Martin now. David was born and bred in Brisbane. He trained at the University of Queensland as a chemical engineer and taught and researched there for just under 4 years. A significant change in his life resulted in his living in Arakoon in Western Cape York for 8 years, and undertaking a master's degree in anthropology at London School of Economics and a PhD in anthropology at the Australian National University. He has worked as a consultant anthropologist in the native title arena, including the WIC claim, has assessed many connection reports for both governments and native title representative bodies and service providers, and has a particular interest and has published in Indigenous governance matters. Can we please welcome
Thanks for the introduction, Judge. I was pondering here that the few of us anthropologists that are scattered amongst us and the majority of lawyers, which is a good thing. But it reminded me of seagulls. If you look at seagulls, you go down to the beach, very often there will be a clump of seagulls in the middle, and then there are always 2 or 3 seagulls off to one side. That's us, that's the anthropologists. And we're seagulls by nature. And I was also thinking about, this is the random way anthropologists think and try and bring something together. I was also thinking about the ways in which groups of creatures and so forth and people are put together. Just to think of some, you know, we talk about a mob of sheep, we talk about a group of human beings, and so on and so forth. There's some wonderful ones. There's a murder of crows. It sounds medieval to me. I looked up what it is for barristers, and it said, and there's a number of options, but the one I remember was a bar of barristers. It wasn't altogether clear if it's one that you lean against. But anyway. And then I thought, well, what is it about anthropologists? What is it? A group of anthropologists such as us here. And I came to the view that it's a confusion of anthropologists. So, with that, I want to start, and this is for the non-lawyers here, just to emphasise what the Native Title Act says that I think is so relevant to how we should approach our work and how lawyers should deal with us and what they ask of us when we're doing our work. It's the section describing what is this thing, native title, section 223. And included in that, it's focused on, quote, the rights and interests are possessed, a critical word, under the traditional laws acknowledged and the traditional customs observed by the Aboriginal people or the native title Torres Strait Islanders, and those people, by those laws and customs, have a connection with the lands or waters. For me, they are very, very, very significant, and I'll explain why. Could we turn it to, it's probably number 3, but the first to be now, I don't know how many of you can actually see a diagram there, maybe, hopefully most of you. And interestingly, the first idea for this came from conversations decades ago with Noel Pearson, who now doesn't agree with this, but I think it's very useful. Native title really is seen as lying in a recognition space between two, what are assumed by Australian law is that there is, obviously there is an Australian law, but then there is the law of the Indigenous group concerned. So it's a recognition space between two, it's treated as an intersection space between two systems of law, which is an unusual, I don't know if there's other matters in, maybe there's some elements of international law that are brought in where there's the same kind of translation, I'm not sure. Next one, thanks. But it's not just it's not just a recognition space. It's also what I call a translation space. Connections to country, which derive from laws and customs, to rights and interests recognised by the Australian law. And for me, that summarises the difference between our role and that of you lawyers. That our role is to understand and be able to explain and set out that system of law and custom of that particular group of people or those particular groups of people in such a way that it's cognizable to Australian law. Now, I'd also meant to refer to, inevitably, I'm referring to the law as I am to the definition of native title. And I should say that my very first ever hearing some native title matter in South Australia, up in Maree Way, was in front of John Mansfield. This is a very long time ago. Well, I think it was maybe 25 years, something like that, 20 years. And there were a dispute between two groups, one of whom had done their consultation and got their authorisation through a group of senior men meeting in a small house in Maree and coming to an opinion. And then the other one was held in Broken Hill, a large public meeting of all the people, Aboriginal people in that region who claimed connections, and that was by consensus. And in my report, I talked about the two relevant sections in the Native Title Act that appears numbers of times, as it does in the PBC regulations. That is, if you've got a traditional way of making decisions about this, you've got to follow it. Failing that, you have an agreed and followed one, right? And after my report had been tendered, then Justice Mansfield said, well, I propose to rule the whole thing whole report as inadmissible because Dr. Martin knows a lot about the Wik people of Arakan, but I don't think he's got any expertise in Australian law, and that was that. So I'm trying it again, and we'll see how we go. But I'm actually just using it as what I call a heuristic, a device. So, what are the implications of the distinction between traditional law and custom and rights and interests? What do they impact on? So, it's my opinion that our role as expert anthropologists is to render the system of laws and customs into terms, as I said before, cognizable to Australian law and relevant to ascertaining whether the particular native title can be recognised, and a set of other things that follow as well. And for example, my opinion that of absolutely central, but not central importance to this, but not all that needs to be considered, but of central importance, is ascertaining the nature of what I call connections of a possessory nature, drawing on that section 223. That the law is not interested directly in all the manifest elements of culture, that particular group's culture. It is those that are relevant to native title. And as I say later in the presentation, that concern with native title, that recognition space, is what it does is transfer the system of laws and customs, the recognition space, sorry, of native title interest, has to be integrated into the wider Australian system of property, which is the bundle of rights and interests. So that's what's being translated, but that's not our expertise. Our expertise is to set out what is that system in terms that can be cognizable to, understood by, be clear in their implications to the law, to the lawyers involved, but do not purport to give, for example, a yes/no question to do you believe Dr. X or Ms. Y that these people hold native title? That's not our role as anthropologists. We shouldn't be giving that view. So it does require us to have a certain practical level and understanding of the relevant laws, especially elements of the Native Title Act, but obviously we have no expertise as such in it. But we do need to become experts in what is accessible to the law, what is relevant to the matters that the lawyers, if there's going to be a determination of native title, what are the matters they want, what are the things that would seem to be relevant in the system as we see it and as we record it that impact on that. Okay, if we go to the next one, please. So, and I've just skipped through this. This is an example from a report I did with two colleagues in Yamaji Malabar Aboriginal Corporation, who represent people in the Gascoyne region of Western Australia. And we wrote, and it was in an area where, in fact, the anthropologist Radcliffe Brown had developed his whole clan estate model, 11 tribes or whatever it was of Western Australia. So it was a very, a really fascinating area, anthropologically speaking. And what we did, what this diagram seeks to do, is to how do you take this, what I'm talking about, this way of us being true experts, but remaining true to our discipline and not giving evidence on what are the legal constructs. What we did, myself and Carmen Cummings and Nissa Kuhn, what we did was to break it down into the three key elements of languages in terms of looking what was and what we recorded in contemporary society. So the first is language. Then there's the nature of the groupings that would hold some kind of title or connection that's a possessory connection under Aboriginal law. And then lastly, the area, the country area itself. So in those three areas, what we did was to look at what the situation was in the past, what it was in the present, around continuities, around adaptations, around transformations, around attenuation, and around aggregation, in each of those. So we use those terms consistently through those three tranches, that is, languages, the nature of the local groupings. For example, clans to extended families, families of poverty, Peter Sutton calls them, and country. And it worked very well. It was accepted. It was a massive claim over a very large area. And I'm just showing this to show an example of the kind of alternative to how the kind of briefing that's offered to too many anthropologists from the lawyers. And the one thing I guess I left out in this, right at the heart of it, was that this was, and these were religious corporations. So these were the groups, the clans and so forth were religious corporations. And there's in fact a wide literature on that. People like Burnt and others, Ronald Burnt. But so all the way through, we traced like what's happened to that. People didn't know a whole lot of the detailed, complex ritual world, the world of the totemic beings, at least not in very much detail. But when you went under the surface and looked how people were operating, how they were talking, how they would go, and when they got into their country, they would call out the spirits of the deceased. All sorts of things. You could see that there still present was not an absolutely secular view, but a view which incorporated a landscape which is not just property, but which has deep spiritual meaning attached to it. But of course, there's other changes as well. We were very open about the changes, about the losses, but we also looked at what are the continuities. So I just put it there as an instance of following this kind of pattern and following around, as I say, what Section 223 talks about, then, and to set it out in such a way that what happened was 2 months later we got a communication back from the state of Western Australia saying we've accepted it with not a single omission or and so forth. So it worked. Okay, so complications in maintaining the distinctions. It's not uncommon for lawyers to brief anthropologists to give, and sorry, we're on the next one here. That's complications in maintaining this distinction. It's not uncommon for lawyers to brief anthropologists to give opinions on what we think on legal matters. For example, what is the relevant society? As I understand this concept of society, it was introduced into the jurisprudence, native title jurisprudence, to answer the question arising from section 223 as to who are those who possess the rights and interests. Now, this is me being the anthropologists looking into that system. How do I understand it as an anthropologist, not how is it to be understood from a legal perspective? However, as I understood the Yorta Yorta claim, which is where the Yorta Yorta matter, which is where this notion of having to set out the relevant society came from the Yorta Yorta matter. It seemed to me that society is not a sociological concept. In other words, it's not the kind of term that anthropology indeed would talk about and so forth. It seemed to me that it rather arises from the need of the law for clear delineation of property rights, which includes what I think of as the, quote, cadastral imperative. That's my term, not the lawyers. That is the need for clear boundaries to the lands over which native title will be recognised. And that's something I want to come back to, because this is one of the things that make it very difficult for anthropologists when the question of boundaries and so forth become really paramount, but are not easily solvable in the way in which the law Australian law sees property rights being delineated. So we do have things to say nonetheless about society as anthropologists, but not directly the society of native title jurisprudence. And I'll touch on that later. Next one, thanks. So there's some complications in maintaining I'll turn now to 4 highly summary examples of matters in which the court has found it necessary to make findings or accept evidence which impact on the particular systems of laws and customs. So these are ones which struck me as having particular import for the kinds of problems that an anthropological approach has when looking at some of the key decisions that have been made over the past decade or so. The first one is I've called it the encroachment of legal reasoning into the principles of the particular law and system of law and custom, and that's the Yalara compensation case. And what I mean by that I'll come to in a minute. It's where, rather than, as my diagrams earlier on tried to separate, this is the law and this is the traditional laws and customs, and here's the recognition space. So this is saying, but there are times when the law does insert itself into and make decisions about what the reality of that system of law and custom is. So that's the first one. The overlapping societies and languages in the Drury case, the encroachment of legal reasoning into principles of the particular system of law and custom, the Yalara compensation, ruling as inadmissible ethno-historical information from hitherto unexamined reports and records, which was inconsistent with an existing determination. That's the Lake Torrens claim. And an instance of the apical ancestor conundrum, a Cape York consent determination. So I'll be very interested to hear the views of some of those attending this workshop around what I'm saying here. But I was asked to be careful and but provocative. So is this possible? We'll find out. My aim here, though, and to make it really clear, my aim is not to critique the decisions I have no legal right to do so or ability to do so, but also it's rather to focus on what can happen when judicial reasoning impacts on laws and customs, which seems to me to be a move away from recognition to transformation. So the next one, please. What might be said about the Drury decision? This is one where the ruling was that were two, as we show in that diagram, for those of you who can see it, two overlapping languages, societies and native titles. This is over in Western Australia, west of Western Australia, Central West. The group of claimants was determined to be the society for the purposes of native title in each case, Group A, Group B. Each had their own separate system of law and custom, A and B. And so there were two overlapping languages, societies, and therefore native titles. That, if I've understood it correctly, was essentially the kind of message that came from it. That was the core of the decision. Now, perhaps this does reflect a translation of the contemporary laws and customs into native title terms, or I suggest perhaps reflects a disputation between the two groups over the overlap area. But there's two related characterisations. They do raise concerns regarding the appropriateness of the recognition and the translation spaces. So is it clear what this is saying is that this, if those of you who are not familiar with the Drury case, it said there are two separate law systems of law and custom, and here they overlap. So what do anthropologists have to say? For example, languages are not necessarily coterminous with a society. There's a very, very interesting work done a long time ago by an American anthropologist. He was mentioned in one of the comments earlier today, Lauriston Sharp, an American guy who came out with all the baggage of the functionalist model that people like Radcliffe Brown and so forth had. Quote, "In studying the population of Cape York Peninsula, I simply could not find a society. I would have to describe it in terms of an ego-centred set of societies. No one individual was the centre of a system of networks which overlapped isotypically with anyone else's." In other words, Lauriston Sharp, was unable to say, all right, this area of Cape York is, for example, the Wick area, and this one is the Kanju area and so forth, because what are the criteria being used? For example, in Cape York, but this is far from unique, there are ritual cults, some of them with origins up in the Torres Straits, involving two brothers in a Torres Strait kind of way. There are others. So the distribution of languages doesn't necessarily mirror the distribution of similar systems of law and custom and so forth. So the other thing too is that what anthropology teaches us is that languages themselves, unlike the way we Westerners understand it, languages themselves are emplaced in the creation period. The creator beings who left the landscape, who left law, etc., also left the languages in place. So the other cases, so I'll be quick now, the encroachment of legal reasoning into the principles of law, in the Illawarra compensation case, the judge found that that was a patrilineal system, that is, it passed from father to son to grandson and so forth. But that actually is not the case. So in there you've got legal reasoning, and a particular reading of the materials means the judge ruled that the basic the basic system of desert people, Anangal people's worlds was through the patriline, and it's simply not the case. I've worked there myself. It's not. Another interesting one, and I repeat, in none of these am I quibbling with the decision. Another one is ruling inadmissible ethno-historical information from hitherto unexamined records, which was inconsistent with an existing determination. That was the late Torrens claim. And then last, an instance of the apical ancestor conundrum. And I was involved in that as preparing a report for the Cape York Land Council. And in that case, a particular group whose senior living person made transparently clear that they were descended from the apical ancestor that was at issue here, but that was on the mother's line, and that was not part of their country. They had nothing to say about the country at issue. So what's happened in the consent determination is that there's a whole set of people who are native title holders in law, but who say they're not native title holders, which is hardly a good outcome. Okay, so I was going to talk a bit about the area that I'm particularly interested in, governance, PBCs and so forth, but perhaps we can leave questions about that to later on. My opinions, my conclusions about what does this mean? What do these kind of views mean for anthropologists and others? So for us, it's important that we do not unwittingly adopt the jurisprudential terms, although we need to be aware of them, like society. We need to be very careful that we don't buy into the notion of society as it's been interpreted in the law, because it can be very different in anthropology. We should not be baby lawyers by referring to particular findings. I've seen this in many reports in native title cases, or referring to jurisprudence. We don't have any expertise in that. It's not the expert anthropologist's task to provide opinions on whether or not the ethno-historical evidence we have considered meets a particular legal requirement. Does native title exist or not? That is not our job. And again, I go back to those two intersecting circles. I think it very clearly, and I'm nearly there, very clearly demonstrates where we should place our work. That is, we work as anthropologists, not as baby lawyers. It's, as I said, our job is to render that system of law and custom into a form cognizable to Australian law, native title law, for the questions that it's seeking, like do they have native title? Is there continuity of an adequate nature, etc., etc. And more anthropologists need to learn how to work in conjunction with lawyers and in collaboration with the particular Indigenous group to establish effective systems of governance for the native title. And this subject was raised just earlier on. For example, PBC, trusts and ILUAs and so forth. That is not something that should simply be left to lawyers, because you have an intersection potentially of two very different cultural mores, different views of ethics, politics, all kinds of things, which means different thinking is required around sustainable prescribed bodies corporate. Okay, in conclusion, my opinions also for lawyers. Whoever the anthropologist is being engaged by takes seriously the need for them to be independent and avoid briefing them to give opinions beyond their expertise or to assist in making the case. It's not enough to simply add the formal legal requirements to the contract and leave it at that. There's too many briefings of anthropologists which are not appropriate and shouldn't be accepted by us. And last and with the most concern on my part, federal court judges. In my own verbal briefing for this presentation, I was asked to be provocative, but not too provocative. So the following I respectfully submit for your consideration. There have been and will continue to be cases where the judge or judges may have to interrogate and come to a concluded finding about elements of the particular system of traditional law and custom at issue. Judges will gain experience over time and become more familiar with the concepts, but they are not experts in the matters. Their decisions, findings, become more familiar. This is the trouble I have scanning text. They become more familiar with the concepts, but they are not experts. Their decisions, called findings, will have significant impact on the claimant's lives and those of their descendants. So tread lightly and respectfully in these circumstances. And then lastly, is it feasible in at least major cases for a senior and experienced anthropologist to be a judge's associate or assistant to assist in translating concepts? Translating I'm using in with inverted commas around it, on matters concerning laws and customs where these arise, which was the practice in the Aboriginal Land Act with some of the early commissioners, and I think was very successful. Thanks for your attention.
Thank you, David, for that provocative presentation. Now, I'd now like to introduce our next two speakers. They will be discussing the mistakes lawyers make in briefing expert witnesses. And we will now be joined by Ms. Wendy Ash and Mr. Joshua Creamer. Wendy, after completing a Bachelor of Arts, did research on West Timor for her Master of Arts. She then began working at Northern Land Council. In 1996, she was there as an applied anthropologist in the Native Title Unit of the Anthropological Branch. She was part of the NLC team, which put through 8 native title claims through the hearing, including the original Timber Creek native title application. Wendy also worked on many other matters, both in native title and under the Aboriginal Land Rights Act of the Northern Territory. In 2008, she went to the University of Queensland as a research fellow to work with Professor David Trigger to better develop better training for anthropologists working in native title. Following 3 years, she worked as a part-time lecturer and consultant, and then became a full-time consultant working in southeast Queensland in the Northern Territory. This included work on the Timber Creek compensation case. In 2002, Wendy went back to the Northern Land Council, where she became manager of the anthropology branch, which now includes 25 anthropologists in the branch, along with 16 others in GIS, land interest reference, and administration. After Wendy finished her presentation, I'll ask Josh Creamer to transition into his presentation. Joshua is a Wanyi and Kalkadoon man. He is a barrister with practice in native title, class actions and human rights. He has appeared in a number of landmark class actions, including Watton and State of Queensland, stolen wages and the stolen generations cases. He was most recently the chair of the Truth Telling and Healing Inquiry in Queensland. Can we please welcome Wendy Ash and then Joshua Creamer.
Good afternoon. I thank the Federal Court for allowing 2 interlopers to present to lawyers. The interaction between lawyers and anthropologists is a favourite topic of mine, as I think the best outcomes for Indigenous people arise when there is a productive tension between our respective professions. David has given an excellent theoretical analysis of the somewhat uneasy and difficult intersection between lawyers, anthropologists and Indigenous people. I'm going to deal with one of the practical matters of briefing from lawyers to anthropologists, which sometimes leads to unnecessarily exasperation, tension and poor outcomes. The slide shows a cartoon drawn by the anthropologist Michael Pickering some years ago, and of course the anthropologist represented labouring at the top of the pyramid, and the lawyer is idly watching, saying, "We've changed our mind, we want it square." The other thing I want to point out is that the topic given to me was the mistakes lawyers make in briefing expert witnesses.
I was rather uneasy about the negative framing of the question, so I've changed the title to be more encompassing of both positive and negative. Of course, I should have communicated this well before now and had a proper discussion with my legal colleagues. I feel very lucky to have worked with many excellent lawyers in my time at the NLC and as a consultant. They have made me a better anthropologist by challenging and compelling me to make my anthropological opinions more explicit. However, I'm bold enough to suggest that there are some negative stereotypes held by anthropologists about lawyers that fit a very few practitioners. For instance, that lawyers can be arrogant, narrow-minded, and unimaginative. My father was a lawyer who had an excellent sense of humour. This was one of his favourite toys.
This is an outrage! My client is innocent!
Other toys included a large collection of Smurfs. In fairness, I also have to acknowledge that although the vast majority of anthropologists are noble, intelligent, and professional, a few fit the stereotype that lawyers can hold about anthropologists of being unnecessarily waffly, unreliable, and off-topic at hand. In fact, an excellent and concise presentation of some of the inappropriate and unhelpful anthropological reports was given to native title anthropologists 9 years ago by Justice Rangier. I entirely agree with his opinion and note a few specific comments. I don't know if you can read that, but it says, everyone in the courtroom has an agenda. For a barrister, it will be winning the case and impressing the instructing solicitor and everybody else with his or her brilliant oratory. For a solicitor, it will be winning the case and trying to keep the client happy. The judge has an agenda too. When everyone else has gone home, the judge is left with a morass of papers, inconsistent evidence, and conflicting opinions which he or she has to sort out. The judge's agenda is to decide the case as quickly, efficiently, and simply as possible. The judge is vitally interested in what anthropological reports say that will assist in deciding whether requirements of Section 223 and 225 of the Native Title Act are met. No more and no less. A judge will appreciate and respect an expert who can write reports in a style and manner which is direct, relevant, succinct, and without surpluses. Justice Rangier goes on to underline what is required for an expert anthropologist. Judges and the lawyers who engage anthropologists want well-structured, well-ordered reports containing headings and subheadings so that the reports are easy to follow. He notes, one way of improving the quality and timeliness of reports would be for the anthropologist and the lawyers to meet and discuss in detail the scope of the report and the issues likely to be in dispute before the final instructions for the report are given. This should occur after the anthropologist has had some chance to reach an informed preliminary view as to the scope of the work required. The sheer volume of work required to be done by the anthropologist and the length of time it takes to complete makes open and frank communication vital. I would suggest regular ongoing meetings rather than see you in a year approach. My presentation here is then a partial response and plea for extenuating circumstances of the anthropologist because of poor or insufficient collaboration between lawyers and anthropologists that leads to bad outcomes for Indigenous people. Terms of reference from lawyers can be confusing, excessively long, and not very useful. However, anthropologists do understand that much of what is stated is directed to the court or a responsive party, and that each case varies as to the various aspects of the application. I asked some of my legal colleagues why there can't be a standard brief for native title applications. And not surprisingly, I received very different replies.
One lawyer suggested that the complexity and confusion can be deliberate in that a particular aspect of the case may be sensitive or potentially detrimental, so that aspect would not be underlined in the brief. Another answer was that the structure of the brief and reasoning behind it may affect the way the expert thinks, and this may limit him or her. I will give another example of a way of interaction between lawyers and expert anthropologists. This is the Timber Creek compensation application, which Kingsley Palmer and I worked on. Fortunately, Justice Mansfield has already spoken about some of the aspects of the case. This is Josie Jones, who was one of the 3 key witnesses and informants for the case. Sadly, the 2 others, Mr. Griffiths and Mr. Jones, have since passed away. A barrister I spoke to recently told me that there is a new verb created associated with the senior counsel who worked on the case. Apparently, his juniors are regularly glackened. This means that they are called upon at 3 a.m. from the Macedon Ranges to investigate a wild and wonderful legal approach and expected to provide a summary by the morning. By then, Sturt has changed his mind. In the Timber Creek case, Kingsley and I experienced something of Sturt's flights of brilliance, but as independent experts, we were able to remain removed from them. In Sturt's defence, as you know, Timber Creek was only the second native title compensation claim and the first successful one. Clearly, Sturt was an essential part of that win and was ably assisted by other lawyers, including Tom Keeley, Jonathan Leebone, and Tamara Cole. They sometimes acted as translators between Sturt and us. When we first began, the core brief was as follows. I won't go through this, but you can see it's a fairly regular expectation. We had done the original native title application, so we had the advantage of being able to draw on that report. So points 1 and 2 follow pretty standard lines of inquiry, but number 3, the effects acts have on the native title and rights and interests, was a new subject that we had to approach in an entirely different way, and in fact, in very much contradictory to the usual proof of continuity. So we had to show what is relevant when an act resulting in discontinuity occurs. The initial Timber Creek native title application followed a fairly standard outline, and again, responding to Justice Rangier, I like the idea of being very clear headings within the report, and I get equally annoyed at anthropologists who don't fill out things clearly. In contrast, the compensation report used the following chapter headings, with 3, 4 and 5, recompense, laws and customs, claimant's right to compensation, taking the same wording as the brief. However, where we had to think unconventionally were in relation to concepts that we elicited from claimants, such as breaking and spoiling, shame and restitution. And these were very, very different concepts that we were able to elicit from the senior claimants who we spoke to. And fortunately, because we had a long-term relationship with these claimants, we were able to do that quite efficiently within a limited time. Similarly, we asked people how they felt about the consequences of acts which included intense personal feelings of shame, guilt, fear, grief, and loss of cultural integrity. And Justice Mansfield has mentioned this, that it was incredibly evident during the case and talking to them prior to that this was an intense emotional thing that they were talking about, and in some ways we felt quite embarrassed about having to prompt these sort of responses from people. I believe that we were able to investigate and present these different concepts because the lawyers had not suggested a recommended way to approach such aspects for the case. So I think we were able to approach such concepts without any direct direction from the lawyers, and were able to elicit what obviously was found to be relevant concepts. Another important aspect of the Timber Creek compensation terms of reference was that the lawyers gave us the instruction to not confine our investigation to acts which occur within the boundaries of compensable acts. As you can see in this slide, there's only 6% of the whole claim area were compensable acts. But when we're asked to look at the bigger picture and not be confined to those acts, we could look at the holistic effect of individual acts. Fortunately, Mansfield concurred with this concept and in fact created a wonderful analogy of a painting with holes in it being damaged in parts, but leading to the loss of integrity of the whole. And I thank Justice Mansfield for that wonderful decision, because I think it really evokes the idea of how compensable acts should not be seen in isolation. I conclude with another observation from Justice Rangier, who says that problems are often due to a lack of communication between lawyers and anthropologists. The instructions given to anthropologists by lawyers are vitally important. Sometimes instructions seem to have a generic quality rather than being specifically tailored to the particular nuances of the case. Sometimes reports dwell at great length on issues that are not seriously in dispute between the parties. A lack of communication with the lawyers may result in an anthropologist wasting time when the report could have otherwise been completed much earlier. I look forward to even greater collaboration between lawyers and anthropologists and hope that more dialogue is possible in forums such as this one. Thank you, Wendy. Can I ask Josh to follow up, please?
I think it's a case between Wendy and I. Do what I say, not what I do. We haven't collaborated at all on this, but I'm sure we'll make it work. I wanted to, if I get my slides up, the work of an anthropologist is a real mystery, I think, to many of us in the room. Lee's laughing. Although we spent some time driving around central Queensland, Lee, and talking, I've never really quite understood how it is the anthropologists go about their business. But this next slide, I think, captures my thoughts in respect of the wizardry and the magic that's involved in the work of people like Lee Sackett and others. So, for any of you who've seen Harry Potter and the really powerful wizard Albus Dumbledore, he has the ability to collect memories and to put them into a pensive. And you can also collect tears, which Harry Potter did to Snape, and you put those in the pensive, and he could see Snape's memories over the last 40 years. And for me, I think that's something in line with what the anthropologist might do, how it is they come to their conclusions. But in all jokes aside, moving on to the next slide, there is a really critical role that we as lawyers play in ensuring the best outcome for our clients and working collaboratively with anthropologists. I won't touch on this too much, but understanding there's a legal framework which really, in terms of the anthropologists, there are two overriding duties: to be independent and impartial. And the case I wanted to look at today in respect of where things do go wrong is the Santos case, so I'll get to that shortly. Importantly, if I can go on just to that next slide, thanks. Now, for any of you who haven't read the Makita case, the Makita principles really are paramount in working with anthropologists. It's been affirmed by the High Court decision in Dasrif, which is there, but recognising that anthropologists are experts in a field which have specialised knowledge in a specialised field. Makita goes through and talks through those principles, and actually the decision of Western Congaloo, which was around 2023-22, is a bit closer to home. Again, looked at these issues on what is an expert. I just might brush over the next couple of slides because it really articulates the Makita principles and the reasoning from that decision. I'll go next to the slide, Nankara. Yes. Now, I'm sure all of you have read this case and the series of cases that have come from it. It's a really interesting series of cases, actually, and could form a really good 90-minute CPD on ethical obligations. It's actually quite interesting to read. But as you'll know, it concerns the Santos pipeline off the coast of the Tiwi Islands. The applicants were seeking relief for permanent injunction in relation to the pipeline and a revision in relation to the submission of an application. The lawyers, the applicants, argued there were significant effects from the pipeline in regards to intangible cultural heritage, so particularly two dreaming stories, and then the more tangible cultural heritage with the threat of the archaeological record which may lay on the seabed or under the seabed being damaged by the pipeline. In this case, 23 Aboriginal witnesses gave evidence, and then there were 26 expert reports, but a number of experts ranging in expertise from anthropological, archaeological, geological and geophysical. And actually, when you were talking about a group of anthropologists, David, I was thinking a hot tub of anthropologists. And in this case, there were two hot tubs of anthropologists as well. So, now, I will talk to two things. I'll talk to particularly focus on where things go wrong with an expert, but there were some things that the Justice Charlesworth was really critical of as well in terms of the approach that the lawyers took into running that case. And this is particularly around the evidence, and evidence wins cases, and the importance of evidence and the importance of ensuring the process of capturing that evidence, but also then deploying that evidence in the hearing setting, critically important. A number of the points that Her Honour picked up on were the failure to use interpreters. And, many of us having worked across a number of jurisdictions. Queensland, our history is different. We had a wholesale mission system, separate from not talking about the Torres Strait here. But because of that history, we generally got educated to about grade 4. So we've got there's some commonality in terms of our ability to communicate with English. But that's certainly not the experience in other jurisdictions, the Northern Territory and WA, where I've worked. I haven't worked predominantly in New South Wales or Victoria or Tasmania. But importantly, the lack of using interpreters was a critical aspect the judge picked up on in this case. Now, one of the things that, and I know I'm talking about experts, but I wanted to emphasise this point because it always does really bug me in cases. And that was the approach to the way the witness statements were drafted and prepared and submitted, in that the judge identified that it certainly could not be the language in which those witnesses deployed. And I think that's one of the really failings that lawyers do in the collection of their evidence, is that we try and, we'll sit down, there's a whole range of processes we can employ. I think the worst process is to sit down and take notes and then draft an affidavit from your notes. And for me, that's an interpretation of the evidence rather than the evidence itself. But in this instance, there were a number of examples where the judge just clearly said this is not the witness's evidence, and the witness wouldn't use these words. And lastly, on that slide, again around language, and that's if many of you will be familiar with the work of Dr. Diana Reeds, and if you're not, I would encourage you to read her work on cross-cultural communication in the justice system. She's given evidence in a number of cases which I've appeared in, but also too, I know she's given evidence in cases in relation to, I think, ASIC or ACCC cases about phone records. So her work is highly regarded, but also adopted by the court. Just referencing again the use of language there, and a considerable amount of paraphrasing or witnesses using that yes/no response, and that issues around gratuitous concurrence. So it's a little bit off topic, but I couldn't not take the opportunity to emphasise the important work that lawyers must do there. Now, just looking at the judge's comments in respect to one of the experts, and there are a whole range of experts who gave evidence, obviously. But there were three themes that really the judge was critical on in respect of one of the experts. In paragraph 253, she really talks to, Her Honour really talks to the importance of expert evidence for her in this particular case, and being able to rely upon that evidence to really distill those conflicting views which exist between the lay witnesses, and that's a critical function of an expert in a case like this. But ultimately then, Her Honour goes on, and I've categorised these in three categories. They're not her categories, but they're my categories. And the criticisms really relate to coaching the witnesses, giving, and this is not in court, but these are pre-court conferences, making statements to the Aboriginal witnesses that were misleading. And then, importantly, in going back to that Makita principles, giving opinions expressed beyond your expertise, and that's something that David certainly touched upon in his presentation. I just put these in here because if you haven't read the judgment, but there was a lot of criticism in the way that there were two maps instructed, and if you do get a chance to look at the judgment, it has all these in it. Really, and if you turn over to the next page, what the judge identified, Her Honour identified in that process was the experts had shown a lot of the witnesses' sites on a map at a particular workshop that was held prior to the hearing. That workshop was organised by the applicant's lawyers. The sites were not known by some of the witnesses before being told. And there was this process where everybody worked together in this meeting to develop these maps, which these stories associated, trying to associate them with this particular area. And the fact that every witness who was going to give evidence was part of this process. So the potential for their evidence to be tainted during the course of this hearing process, or during the course of this meetings. And ultimately what the judge was particularly critical about in terms of the coaching was a particular expert. And look, I wasn't in the case, so I don't know, I'm only just reading what was said in the judgment, and others might have different views. But the witness, the expert with one of the lawyers really formulated or developed or coached that evidence and really distorted. And it's a bit like what David said, that there was no particular knowledge in relation to some of the witnesses about this site, but the way in which the process developed, that people then started to assume that this evidence is associated with this particular site. So really influencing the evidence that those witnesses would give. This touches on, again, misleading, sort of goes into the same point, but witnesses started to rely upon that advice by the expert and how those maps were represented. And the judge was quite critical because that second point there, that on her assessment, those maps could not be a reasonable measure said to correctly represent that landscape at the particular time. It was put that 20,000 years ago, or I forget the particular time frame, but a number of thousand years ago, the landscape was different. Obviously, there was no inundation of water, and this particular site, or these sites, would have been significant at that time. And I guess the maps that were used to support that hypothesis, the judge just found that they were not credible. On to the next one. So the experts advised the witnesses, the expert advised the witnesses of his previous experience in another jurisdiction, again using a similar type of process, where he said a man from the Pilbara, looking at a particular map that had been prepared, recognised that his dreaming story laid under the sea and could identify in that map. Now, the judge found that those comments were not accurate, and that's what the second heading then does. Her Honour says that it may be reasonably inferred that the statement about Mr. Douglas and the untrue statement at the earlier mapping exercise, which had been used to stop an earlier petroleum development, could only have been deployed at the beginning of this particular workshop. The coaching attendees about what they might say in response to the maps of the submerged landscape so as to achieve their objective of stopping the pipeline. No other reasonable inference was available to Her Honour. Now, those 2 points in relation to coaching misleading were then followed up by the expert giving his opinion about evidence, about issues that were well outside of his expertise. You'll see there I've set out a bit of the CV in relation to the expert. Her Honour says that his opinion reinforced my concerns that Dr. O'Leary was not sufficiently independent so as to qualify as an expert in these proceedings. The postulations as to whether or not the crocodile story man exists in deeper time than the foundational myth explaining the creation of Tiwi Islands are obviously outside of his expertise. And then the issue around the concern of lack of independence only reinforced Her Honour's view that there was a lack of scientific rigour associated with the opinions. And then the last one, really picking up that point about giving expert evidence outside the expertise. I've just noted the Malone judgment. 2 points I wanted to finish up on, given the time. There was a matter I was involved in some time ago, the Wyman matter, where there was a dispute about an expert and there was a decision. You were in that, weren't you, Lee? Yeah. I think when I read the report and I saw the CV of the expert, and he'd mentioned his experience driving buses and he was responsible in managing change, I thought that was certainly an issue. And then ultimately there was a introductory application, and that evidence wasn't allowed, I think, from that particular expert. But then this one is a little bit closer to home and raises some interesting issues. Now, Malone, Western Kungaloo, Central Queensland, I won't talk too much about this because a lot of the claims associated in this area are still on foot. And I think there's the consequences, and Kim's there in one of those, Gungaloo, the consequences of the decision in respect of one of the experts' reports that was not allowed into the, was not admissible, I think has consequences across those other matters. But what we see there is the state objected to one of the applicant's reports. The applicant had relied upon the report of Dr. Kenny, and Dr. Kenny was instructed by the state to prepare a report, and there was an issue about whether or not Dr. Kenny's report was admissible, and only in relation to this specific matter. Conclusions you'll see on that last page, I think, that Dr. Kenny's report not be admitted. But in any event, Dr. Kenny gave evidence in Gungaloo, and a number of other cases are still on foot, all stemming from the same report. My role was really to, I guess, provide some general balance or commentary in respect of both Wendy and David's paper. You know, there's nothing really you can contest in respect of what we've said as panellists. I think they're ultimately, as lawyers, when we're briefing experts, there's a number of issues that we need to be aware of, because when things go wrong, they really go wrong. So thanks.
Well, Well, thank you, our very, very interesting speakers and our very, very interesting presentations. We have until, say, 3:45 for questions, if people would like to make any comments or ask any questions. Well, perhaps I can start. I'll get the ball rolling by simply saying I was very interested, particularly in all the presentations. David, I just want to say, I hear what you're saying about language used in court decisions, how it may not necessarily be the language of the anthropologists. But can I just defend myself and my judicial brothers and sisters by saying judges don't claim to be anthropological experts. I'm a simple soul, frankly, in this area. I'm interested in what I'm told. You tell me, your lawyers tell me, the other side's lawyers tell me. That's what I'm interested in. So I will soak up what you tell me and I'll try to churn it out in a way which can be translated into something which can be enforceable by the courts. So I'm not interested in making anything up of my own. That's just not the way judges roll. I'm only interested in it's a bit like the old, those of you who are old like me, you might remember Dragnet. Give me the facts. Just give me the facts. And I'll apply the law myself. So I guess I just want to say, for me, the anthropology is critical. I said at the beginning that the anthropology will not only determine, for me, the outcome, but potentially the pathway. If the anthropology is there, it might be something, parties may go to mediation, may be able to get a consent determination quicker, depending on the quality of the anthropology. Can I also just say, I was thinking about tensions between lawyers and anthropologists. Perhaps there's some tensions between courts and anthropologists as well. If I can just say, back in the day, when I was a baby judge, I used to say, why are these anthropologists taking so much time? Why is it going to take another year or something? I understand it's a huge endeavour for anthropologists to collect all the information. And can I also say that the other thing about anthropologists, and we're talking about qualities of anthropologists, I think someone was talking about that before, you must be people persons, I imagine. You have to be. Unlike lawyers who sometimes are not, but anthropologists, surely you have to be. If you're not able to communicate with the Indigenous people of a particular area, well, you're not going to be able to get the information to put into your report. I imagine, surely that's the case.
Sure. So in terms of the last one, it's essential. It may not be a matter of formal language difference. We might speak English, and so does the person that we're working with. Yeah, but it's a matter of placing it against the requirements of anthropology to see what's the underlying system in relation to the question at hand. As I said, it was what is the law interested in native title cases? There's a whole set of things, and continuity and so forth, but critically, I think it's this question of is there information that the claimants, if we're talking about these kind of matters, have connections under their laws and customs to such that they have connections of a possessory nature. That is things that relate to the legal questions. And I obviously I didn't explain it closely well enough. I I was saying that we need to make sure we change our language so that we make it, we don't write it as if we're writing an article for a journal. We write it such that our opinions, setting out the factual basis for those opinions, are cognizable to the law. That is, that the law can see what's there, and it is then the law, I beg your pardon, who translates that into rights and interests. Now, some anthropologists disagree with me quite vehemently about that, but I think if I was to give opinions on, do you think the Wick people in this area have a native title, I might say as a layperson, yes, but as an expert, the native title is a legal construct.
Agreed.
So that's why I'd call it a translation space. And our job is to translate it into a form which is cognizable to the law, but we do not give opinions on the matters at hand.
Yeah.
So that's the approach that I think we should take. And the claim that I talked, that the example I gave, was a very, very complicated claim. It was over a very large area. There was a lot of attenuation of culture, but it was, as I said, the area where Radcliffe Brown developed his whole model of clans and estates. And there we were, that's the one we were doing. And we followed these principles, making it accessible, not giving our view as to whether there was the relevant continuity. That's a legal question, not an anthropological one. But what are the changes? What were the causes of the changes in law and custom? Clearly they were massive ones. What's there? And by putting the spiritual nature of connections at the very heart of it, we came up with really interesting data. And like 2 months after that report was submitted, the whole report was accepted without a single word change for consent determination. So I think it's don't be baby lawyers on our part, but do understand what the law works and do write it in a way that's accessible. Justice Rangya, in a talk to the Centre for Native Title Anthropology, rightly critiqued the kind of language that's sometimes adopted by anthropologists. Keep that for the journals if that's what you want to do. Make it accessible, plain, straightforward, accessible, etc., etc. But don't veer into, this is me, not Justice Rangya, don't venture into offering opinions on matters. And our experience was doing this really freed us up to write a good report, clear, accessible, and on point. We weren't playing baby lawyers.
No. Can I also say, sorry, I have a question over here.
I was going to ask David and Wendy if either of them had experience with the hot tub or the current evidence, and how do they find that in relation to dealing with both the judge but their co-anthropologists?
Hot tub or cold bath? I've had both. So I've had experience of that. I think it needs to be used more. I think it requires careful managing by those who are managing it. There's some pretty dominant characters amongst anthropologists. They're the solitary seagulls who go their own way and are hard to get out of that particular way of operating. But I think concurrent evidence, having experienced that, having robust meetings where trying to work out what can be agreed and so forth is useful and can be very productive. I think the more of that's done, the better. And I suppose the last thing I'll say is it must really worry you lawyers. I find it really difficult to understand why in so many cases you've got 7 different anthropologists and each of them somehow is producing evidence in favour of the people engaging them. I've had one particular claim in mind, but I won't mention it. I think there needs to be a lot more care taken by lawyers in briefing and ensuring that the anthropologist really is being independent. But you see, it's when if your lawyer is an advocate for his or her clients, it's hard for them to be independent. They want the case to be won, and so there's this subtle pressure on the anthropologist to produce the report they want. So anyway, what do you...
Look, I've had generally good experience of hot tubs. There's one of our colleagues, sadly, he passed away recently, was known for producing quite florid and academic reports, but when he was in a hot tub, we came to agreements much more easily than done, passing back reports, responding to each other. So my experience has been generally positive. Again, agree with David, as long as they are clearly, the issues are clearly demarcated with the assistance of lawyers. And just the other comment that David made, I think is going to a topic we had discussed in the previous session, which is that one of the problems we have, so for example, we have the advantage in the territory that we do have 50 years of land rights legislation and research, and it's, for us, that's invaluable. And with that, the preference is that we do a regional research first, and then we determine where different groupings are. But I think the problem is we then have responsive claims, so we're sort of forced in a position to look at particular small area of country, which is incredibly complex to sort out unless you've done that preliminary research first. So I think that's a conundrum which is pretty difficult to solve, because we do understand we want to preserve rights of the claimants.
Question over here? Or was it?
Oh, there was one there.
One there first.
My question specifically to Mr. Kramer. As one of the only Indigenous panelists today, possibly the only one, I was just hoping for some reflections on how we could make native title a more culturally capable jurisdiction, whether that's through our workplaces, our hiring practices, or even how the court could operate. We've had some fantastic innovation through on-country hearings, but you're an innovative man, Josh, and perhaps you know more than us.
Thanks, Imogen. One of the things I thought we did really well at the inquiry was a trauma-informed approach. I don't think we have it right in native title. Recognising that sitting down and speaking with witnesses about the types of issues that we are canvassing in native title raises trauma. It's the history, the loss, the time in the missions, but and it's when you go outside this space and you realise there's another way to do it, I think that's something we can do a lot better in this jurisdiction, and that is having experts, whether it's psychologists, etc., or experts in trauma embedded in your team to look at your practice. We've developed specific practice guidelines that were reviewed by experts in trauma, and the evidence in the truth-telling healing inquiry in many ways was not much different to the types of issues that you canvass in native title. Particularly, and so I think that is something that we could do in protecting the people that we're working with a lot better by adopting those types of practices.
Okay. Another question over here? Yes.
I'm very interested in Wendy Ashton Department's experience of, I'm interested in your experience of having given evidence in court. In particular, I'm interested in the emotional or personal experience of what it's like to be a witness. I've been in court a lot, but I've never happily been a witness in court. I'm curious about how that impacts on the person who is called on to give evidence.
That's interesting. Maybe I could talk about one which, do you want it in native title arena or in the broader than that?
I'm interested in your personal experience, but
yeah.
that might be, yes.
So in the WIC claim, I was along with Peter Sutton. He was the main. I was an ancillary kind of. So that wasn't in court. It was out. It was spending a day with Queensland lawyers for the Queensland state and so forth. And in the claim that I mentioned here in Western Australia, the one in the Gascoyne region, those kind of, there's not interrogation, those kind of situations, they were very productive in all cases, and in both cases, and they were also very emotionally for us as experts, or for me in one particular one, very easygoing. People, there wasn't anyone trying to. People would, in the consent determinations, they're not trying to trip you up. They're wanting to make sure that the story's straight and so forth. So it's different. In a couple of others that are not native title, in two different consumer protection ones in front of federal court judges. One, again, Justice Mansfield, again, he had, and probably rightly so, but, well, I could understand why, was proposing to not accept my paper because of, the really critical question: what expertise do you have to give these opinions, right? We had a break, and I talked to counsel for this case, the South Australian government, and when we came back, I got them to ask me a couple of key questions, and then, in fact, Justice Mansfield took over the questioning. And it was a question. It was a guy would fly over from Western Australia, and he would purport to sell things to Aboriginal people in local young mothers, young Aboriginal mothers in communities. I think that was very, what's the word? Being cross-examined directly by a federal court judge is difficult, but it also turned out to be very productive. So I think a lot depends on preparation. It depends on maintaining a calmness when you are the witness, even when things are going awry and so forth. Because, and I think also, despite whatever else is going on, to keep a kind of despite sometimes being challenged, like your expertise challenged, I think that not rising to it, bait it sometimes is, but being absolutely open. I think being open, honest, being explicit about your limitations, as well as where you feel very strongly that you have done the research, you have made, come to a conclusion, and it's absolutely defensible, then I think managing to be calm, even when matters around you are very stressful. Now, that's not the kind of luxury that's available to Indigenous people themselves when the very process is bringing up trauma because of past experiences and so forth. It's a very different kind of situation and needs to be dealt with in a very different way. But I think a lot of self-management is important for an expert witness as an anthropologist, and to be constantly aware that the way you think needs to be made open and transparent to the court. It's absolutely critical, because if the court doesn't understand what you're saying, or doesn't understand what you've written, then you're in trouble. And that happened to me one time, except it wasn't the federal court. It went all the way to the High Court. And that's where I probably haven't been clear enough in what I said, and that was very difficult to deal with.
I'm conscious of time. Last question, President Smith.
I'll try to keep it short, Judge. Wendy, that was great, the comment about the benefits of regional research, and I agree with that. I think that we could have avoided a lot of overlapping claims from the outset that was around in the early days with regional research, and I think strategically it's critical to how mob plan. I just want to extrapolate a little bit on that concept about how we know that our old people, our knowledge holders who are vulnerable are passing away, and the evidence that we will need to gather from those people will be required in multiple under multiple acts under the Native Title Acts, and possibly compensation, variation applications. It has its utility in objections to the expedited procedure and a multitude of other areas. So my question, and it's probably to the panel here, is there a way of actually drawing out that rich evidence so that we don't have added trauma by a series of research reports having been obtained from the one person, that's capable of traversing the myriad of native title issues that we have? I know that's a very difficult question, but that's the real life challenge that we have at the moment with vulnerable witnesses and the multitude of matters that are coming across the system. And I suppose, finally, Josh, to you, there's probably going to be an interdisciplinary way of dealing with that, and there might be some risk about how, having regard to the Santos and Barossa matter, how anthropologists and lawyers work collaboratively to develop a research piece that's capable of meeting the broader purpose for which it might be used down the track. I know there's a lot in there, Judge, sorry about that, but to me it's actually a question and a challenge for the future. So yeah, go away, try your best.
I will just say one quick comment. I think the evidence of that generation has relevance broader than just the native title jurisdiction. And that obviously the work around truth telling. So I think there's a real importance of capturing that generation's evidence. However, it might be used over the next 150, 200 years at the moment, but I'll hand it over to the two of you.
I think this is an incredibly complex question, because for me, repatriation is something that we're trying to work towards. But if you do that badly, like, I am not an expert in a particular Aboriginal society, and it shouldn't be up to me to say, well, you should be doing this because your father or your grandparents or whoever it is said this 50 years ago. So one of the dangers of, there are two sides to this, obviously it's incredibly important we retain and get the evidence as it stands today, but one of the biggest problems is allowing change in Aboriginal society. And if we say, well, this is what happened 10 years ago, we are taking away the current leaders of Aboriginal society, their ability to say, well, our culture is changing all the time, and we have the right to do that. And so it has to be done incredibly sensitively, because we do have particular information, but that information still has to be determined by the current Aboriginal people themselves, how they use that information. So I think it's a very complex field that I'm constantly worried about, because I don't want documents then to be used against people into the future, saying you're not a real Aboriginal person. It's a very uncomfortable position.
David, anything you want to say?
No, I think we can. Look, it's endlessly complex there. All these things are interventions into Aboriginal people's lives, isn't it? All of them. And it's a matter of trying to not disempower people with good intentions. That's almost the worst sin, is to do that.
Can I just say something very, very briefly, and that is this. I heard what Josh said before about coaching witnesses. Obviously, that's not desirable. sometimes, and I'm looking at cases right across the spectrum of the federal court, not just native title. As a judge, sometimes I think, thank heavens for the affidavit. And thank heavens someone sat down with a witness and helped them articulate their thoughts in a way which can be put to the court. Okay, yeah, maybe you're not using the exact same words that person would use, although you would hope that most of the time when people are drafting, lawyers are drafting affidavits, they are using the words of the witness. But I just think it must, and I have been a witness, in response to that gentleman's question before, it was horrible. I hated it. This was in a Royal Commission many years ago when I was a senior regulator. And I'm always really careful with witnesses because I know that it's horrible for them in the witness box. I'm assuming they're not enjoying themselves at all. But sometimes I think affidavits, at least it's there, it's on the record. If it's read into it, it's on the record, it's preserved. I just think getting affidavit evidence is not the worst thing, not the worst idea I've ever heard.
I think the work the court's doing, recording the witnesses now when they give evidence, I've seen that in stolen wages hearings where we've just put the video up out on country. I just think capturing that is really powerful, and that becoming part of the court record, who knows how that'll be used over time. But I think, when we can capture witnesses speaking, even if it is in response to lawyers' questions, is pretty important.
Yeah. All right, can you also all please join me in thanking our very eminent speakers. I'll invite Justice Rangier to come up and make the closing remark.
We'll stay here, but I don't have much to say. So to thank all of you for attending today, and to thank all of our speakers for the most informative discussions that have really given us some food for thought today. Please thank all of our speakers.
Can an affidavit actually be used?